As an existing tenant, I am paying rent to the developer. But today they have come for demolition of
Nothing doing. Sorry.
Yes, my lord.
Nothing doing. Sorry. File your petition. Give your slip. We'll see that. No one.
Lord,
Tenant. We'll see that.
But only thing is, well, the
the
building,
same.
we are in possession, my lord.
That's okay. That doesn't entitle you to be there.
No, I am only saying, my lord, that there was a restraint on the corporation for a period
If
of
they,
7 days.
if they are going to violate any of the orders passed by this court, they'll face the music. They'll face the consequences of that.
Well, I am not saying that they are going to violate the order, but my lord, the coordinate bench gave this time so that some modification could be obtained before the another division bench. Division bench is not sitting regular basis. So, my lord, that period, if it can just be extended so that we can apply before.
I'm not extending any period. Give your slip, we'll see.
My lord, kindly give us leave to move the writ petition.
File it, mention it. We'll see.
Lord, may I have your lordship's kindly, Lord, to mention item 276 of your lordship's list. Lord, the corporation, despite issuing a stop work notice, Lord, I cannot even enter my house. In front of my house, in front of my Lord pathway, they are making construction without a plan. There's a stop work notice I have annexed.
Mr. Bhattacharya, give your slip.
Lord, I'm giving my slip. Lord,
Lord,
may it appear, Lord, any day as per your lordship's comments.
We'll see that.
Lord, may I be permitted to mention one matter in your lordship's list, item
They
number?
have mentioned the grounds of urgency in the.
But it's mentioned that should I give them another notice, the corporation, if my lord fixes it on any day, I can give them a notice and come back.
Should give
We are
them a
mentioning upon notice. Upon notice, we are mentioning.
We'll see that.
My lord,
to mention one matter. Petitioner is a septuagenarian citizen, my lord. Where in front of his house, vendors have encroached the ingress and ingress, and they are threatened every day. Day in and day out, he is being threatened, my lord. The encroachment is in, my lord.
Vendors encroachment, they have a right to vend. How do we know whether
It
they
is
have
not
a
being
right to?
implemented, my lord. A public
Give
interest
your slip, sir.
litigation
Give
is-
your slip. We'll see that. This has not happened today. They started sitting since yesterday.
Okay.
Since when?
That I have to take instruction, my lord. It is
Since when, sir? You think it happened yesterday?
no, my lord. This is
Then?
not,
Must be going on for years together. What is the urgency today?
my lord. He is being threatened day in and day out, my lord. He's
If he is threatened, go to the police station.
I have,
But as far as this is concerned, this has not happened overnight.
my lord, I am
that you
praying for
come rush into the
implementation
spot.
of that 2014 Act, my
All
lord.
right. You have
A
given
public
your
interest
slip. We'll
litigation
see
is
that.
going on. The state has not implemented that act, my lord. I am praying for that also.
We have well file a separate petition. Are you asking for the inspection to be done or the survey to be conducted under section 3 of the Street Vendors Act?
Yes, my lord.
Are you asking for that?
No, my lord.
Don't say things which are not correct. Yes. Give us the
Non-prosecution.
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 my lord, I am mentioning upon notice, my lord, for upgradation, my lord.
Give your slip, sir.
Lordship, may I be permitted to mention from the list of Honorable Justice Kaushik Chandra, Lordship.
Yes.
It's a very urgent matter. Abruptly, suddenly, my electricity connection has been cut off, Lordship. I made a representation before the authorities concerned, Lordship, but there has been no steps taken.
Give your slip.
Lordship, I am praying for your Lordship's leave to file this writ petition. Move it on Friday, Lordship. Because without your Lordship's leave, if I file
When was it cut?
the electricity has been cut off in the month of June. I have made my representation in the month of June.
Month of June.
Yes, Lordship.
And
Lordship, I am led by Mr. Chakraborty. Lordship.
yes, Mr. Chakravarti.
There is a suit which is pending. Now, in that, they have obtained an ex parte order, decree, my lord. We have challenged that by filing an application under Order 9, Rule 13. Now, my lord, as soon as we serve it, instead of executing the decree, my lord, they have cut my electricity so that I leave the premises, my lord. I have given a representation on 24th of June, my lord. Now, my lord, I am out of electricity, my lord.
For 1 month, you have been out of.
No, my lord, not for 1 month. I have filed it on 23rd of the Order 9 Rule 13 before the learned court below on 23rd of.
When was the electricity connection?
My lord, in the mid of June. In the mid of June, I have thereafter given a representation, 2 representations to the authority.
Yes. So what is the urgency today?
My lord, the urgency.
You have been without power for last 1 month.
Not 1 month, my lord.
We are on, what is the date today?
My lord, today is July, my lord, mid of June, my lord. 10 days I'm out of
24th,
electricity.
you are saying that you had made a
24th
representation.
June, my lord.
Give me the date when the
The
electricity
24th June,
connection-
I have given the representation to the authority.
When was it disconnected, Mr. Chakravarti?
My lord, it was disconnected in the mid of June, my lord, 16th of June.
16th of June.
16th of
So
June.
1 month. What is the date today?
My lord, today is we are on 2nd of July, my lord. Yes, my lord, 15 days, my lord, there is a delay, my lord. My lord, only if your lordship grants me leave, my lord. Grateful.
इसको डेट दे दो, इसको लिस्ट करा दो. Today is what? Friday.
Yes.
Call the regular matter. Yes, Mr. Banerjee.
I appear on behalf of the petitioner. May I file my affidavit in reply? Corporation has filed its affidavit in opposition. Lordship may fix it any day, my lord. Interim order expires today. My lord fixes it any day. Interim order was made on 11th of
Affidavit in opposition on behalf of respondent number 1, 2, 3, and 4 is taken on record. You have filed your exception. Reply to the affidavit.
I filed my reply. He's filed his opposition. I filed my reply.
Reply to the said affidavit on behalf of the petitioner is also taken on record. Interim order. When was the interim order granted?
11th of June 2025.
This is property tax.
Property tax.
Property tax.
Yes.
Interim order granted by an order dated 11/6/2025 is extended for a period of 2 weeks. Listed next week.
Obliged. Deeply obliged.
Next week, keep it on Wednesday.
Wednesday.
We'll finish it off.
Wednesday.
Sir, we'll finish it off on Wednesday.
Yes. Good morning. Grateful to the 9th July.
Well, item number 2, malab appealing for the petitioner in this matter. Malab for extension of interim order, there was a direction
in this matter.
malab the Bidhannagar Municipal Corporation, there was a direction on
Where's the report you are appearing for?
State. But I have
Who
today.
appears for the Bidhan Nagar? Mr. Nag?
Mr. Nag is appealing.
Yes, he's here.
Look, today there was this is under the extension of interim order hearing.
But you have to file your report,
But
Mr.
we
Nag.
shall file.
We can finish it off, no? Why unnecessarily extend the?
But we'll give a short date, Millard, we shall file the report. Whichever is convenient.
There's no point of extending interim order.
Millard. But we do not have the report today. That is the difference. There are 2 floors which is unauthorized, Millard. That is what.
Malab we have provided the sanction plan, malab that has been granted to us, and we have also provided the receipt of 15,91,000 received by the Gopalpur municipality. That was the adjudication, malab my Lord Justice Chandra malab directed them to file a report on the basis of that.
Millard, will
Learned.
kindly take up page 21 of the writ petition.
If you would have filed the report, I would have finished it
Millard,
off.
subject to correction, Millard.
Yes,
Millard, this is the reasoned order which has been passed.
Yes.
It's a 5-page reasoned order, Millard. Millard,
Yes,
we will not be able to travel beyond this. Whatever will be the report,
It's a direction, Mr.
Millard. Millard will give a short date, Millard. We shall file. Millard, just in prayer, Millard, do we need to file the report in affidavit or we can?
It's the direction is that.
Millard, then will give us a week's time.
Affidavit. Take down learned comes for the respondent Bidhan Nagar Municipal Corporation seeks and is granted further time of 1 week. 1 week.
1 week.
1 week to file his report by way of an affidavit as directed by this court by order dated 18/3/2025. exception to the said report. Learned counsel for the petitioner seeks and is granted 1 week,
Yes, yes, ma'am.
1 week to file exception to the said report. Full stop. List on. Give after 5 weeks, 4 weeks. Interim order granted. Interim order is extended further for a period of interim order granted earlier by order dated 18/3/2025 is extended further for a period of 5 weeks.
Grateful, ma'am. Grateful.
Sure. 5 weeks.
Good.
We'll have it on 30th, we'll finish it off. File your report.
Item 3, my lord,
Yes,
it's appearing for extension. On 19th June, my lord, the interim order was granted. On 24th, I mentioned this matter for extension. Immediately, as while your lordship, my lord, joined after the second bench. On 25th also I mentioned. So there was direction on the part of the corporation to produce all relevant records, and the interim order was granted. Therefore, my lord, if your lordship will extend it and let it be fixed with same direction.
yes, Mr. Banerjee.
Some time may be given, I will come with
Same
it,
direction, with same direction.
with original records. also.
Yes, yes.
I'm appearing for the private respondent, my lord.
Produce relevant
Mr.
records.
Banerjee, the
on the
report
date
which
of-
has been filed,
That is in connection of with another proceeding.
another proceeding.
Yes, therefore they were directed to file it.
In another proceedings.
Yes, no. Before the court, they file another proceeding.
Some other
Therefore,
matter,
court
you have
directed
filed a
them to file
report
it.
in this case.
I was little surprised to find that how another case.
I'm for
report
the
has
private respondent in this matter, my
come.
lord.
And this is available in the court.
Yeah.
This is in
Okay,
connection
okay.
of some
Madam.
other saw and
May I, my lord,
property.
make some submissions if my lord may kindly allow?
No, sir. No need for any submission.
But this order, may I, my lord, only 1 minute.
Yes,
But this order which was challenged, my lord. My lord,
The key
in
order.
respect of that, my lord, the principal order of this High Court, my lord, there is a contempt proceeding pending.
yes.
Now, my lord, on the basis of the orders passed therein, the Habeas Municipal Corporation has complied with the order and this order has been passed. Now, my lord,
Our details.
indirectly, my lord, now, my lord, the petitioner is trying to stall the contempt proceeding, my lord. May I say, my lord, the petitioner, my lord, have been heard, which would appear from the order of demolition itself. Kindly takes up once, and this is an admitted unauthorized construction going beyond the sanction plan. 2 floors, my lord, have been constructed in deviation of the sanction plan, and there have been, my lord, deviations in all the floors. But kindly takes up once the order of demolition, it will be clear from the order itself, my lord.
Sir, they have to file their report.
Indicating that they have complied with the earlier order, nothing more.
Yes, that is,
And that was the direction given by the other
that
coordinate
was passed in.
You show that the order passed by the other coordinate bench has been complied with. My specific case is that despite such order being passed in a writ petition, the corporation have not complied, my lord, the duty.
let
For that records were directed to be produced.
kindly, my lord, apart from the technicalities, my lord, there have been observations that
But as I was scared of the content proceedings, I have already, demolition date has been fixed thereafter.
I am not a party, my lord, in country.
he
don't.
did not need
I have
to
a
be.
party there
It is against corporation.
and,
Just a minute, sir.
I'm sorry.
and demolition work has been carried on that. So we are carrying with the contempt also. We are continuing.
Very good.
Now they are, my lord, coming with that now produce the records. This will also hinder the contempt proceedings also, my lord.
Let the petitioner make
I
submission.
know.
Why will it hinder the contempt proceeding? There is no stay.
It's completely
There
separate.
is a stay.
There is a
1
stay.
week stay, my lord, which has been
Stay
expired.
Granted, my lord.
My lord, stay was granted on the ground that.
When you file your report, Mr. Banerjee will finish it off. The
that
stay has been
also
granted by.
has been applied. Only the extent of inquiry is
Wait.
that there is an earlier order which directed, my lord, that they will do certain things as contemplated in the order. they produced a report on the last date, which belongs to another proceeding and another case.
Let him produce a sanction plan, it will end everything. Let him produce a sanction plan, it will end everything, my lord.
So that they have completed.
We'll see that, sir.
I'm sorry. I'm sorry.
Learned counsel for the respondent seeks and is granted 1 week time to file his report. Full stop. The report handed over to this court on the earlier occasion was in respect of another writ petition. Full stop.
Just say one.
The respondent
Corporation. Two and three.
the respondent shall also comply with the direction of this court dated 19/6/2025. Let this matter be listed after 10 days. Let's finish it off. After 10 days, keep the matter.
Interim order was there was existing.
It is.
Tuesday, 15 July.
It has expired a week before, my lord.
On
Interim-
24th,
When is the interim order expiring?
it expired on 27th. I mentioned this matter. on
Interim
24th.
order is extended
motion is
further
being
till
joined.
20th of July.
Grateful to that, sir.
20th of July,
Grateful. to that, sir.
I will come with the report in the meeting.
we'll finish it off.
Yes, they will comply the order and show that it has been complied. I'm grateful. Lord. It's only to limited to that extent.
Let us see, sir. You have made your submission.
I'm
How
sorry.
many times will you repeat yourself?
My Lord, I was.
I have got it.
Yes, but I am
You said
grateful,
the
Lord.
same thing 10 times.
I'm sorry. I'm sorry.
I understand.
15 July.
Repeating yourself doesn't make your case better.
No, my Lord, the difficulty came in that last date. I thought that the report is of my property looking into Sao because the
All
surname.
right, even I have noticed it, sir. This court is in the habit of reading something.
I am extremely sorry, my Lord. It was my mistake on last occasion for which direction.
Lord, I am for the
Item
petition
number
of
4, my lord, I am appearing on behalf of the private
Lord,
respondent, and in
I am for
item number 5, my lord, I am the petitioner.
Lord, I am in item number 4. Lord, I am for the petitioner. Lord, I must point out.
But there is a
Lord, before you
division
lodge-
and judgment.
Lord, I am pointing out, Lord, the demolition order which has been passed, your lordship, Lord, this writ petition has been filed for implementation of that. Your lordship times and even gives, Lord, the Howrah Municipal Corporation to comply with the self-demolition notice which was passed, Lord, to unauthorized floor. Lord, the last order of your lordships, Lord, is being carried out, Lord, before the honorable division bench, Lord, in the vacation bench, Lord, my client could not appear because on that very day, Lord, the copy was served. Nevertheless, Lord, what happened, Lord, it has been posted before the honorable division bench that as if his application, one application for regularization is pending. So ultimately, the honorable division bench directed the Howrah Municipal Corporation to consider their prayer for regularization, which, Lord, we all know what will be the fate of that. But ultimately, given an outer limit that this exercise has to be done within a period of 4 months. So, Lord, already 1 month is going to lapse. Lord, your lordship can, the outer limit is 4 months. So, Lord, your lordship can ask for a report with regard to the prayer for regularization. What is the point on behalf of the Howrah Municipal Corporation? So, Lord, I am not on that, Lord. Whatever the division bench direction, Lord, let that be carried out. Because I know, Lord, we all know what will be the fate of that regularization. It is a building without any sanction
In
plan.
the division bench, I was there. I suggest, I have prayed before the court that the circumstance will be the same. Result will be the same. We will consider, but we cannot consider regarding that regularization is impossible in so many height. When there are so many height, the division bench said you consider it within 4 months. Thereafter, in the meantime, you stay. I stay the corporation to continue. Already on 28/6, we have given the date of demolition for 6 days because we are scared with the order of this honorable. But the honorable division bench has stayed it for a limited period for 4 months, and for that reason,
outer
we have
limit
to stay
will not-
our head.
Subject to correction, the outer limit given is 4 months. So let the corporation take their call and
Your lordship
report
kindly see
before
the
your
order.
lordship. And the next, my lord, writ petition.
That's the order of the division bench.
Yes.
My lord, 3rd of June
Sir,
20.
give me the order, please.
3rd of June 2025. my lord. Oh, अच्छा, अच्छा. राम दीदी.
To decide the application.
Yes. Lord, only.
Let it be adjourned. Finite time, my lord.
No, Lord, your
them-
lordship
let
makes
them-
a returnable date for filing the report. Lord, the division bench has not directed that it will be, Lord, a never-ending process. Outer limit is 4 months. Mr. Banerjee can.
Let this matter go out of the list with liberty to the petitioner to mention.
Grateful, Lord.
Lord, the next matter is item number 5. They have challenged the demolition order. But that your lordship can take down. Lord, there is no difficulty. Lord, the demolition.
Both the matters go out of the list. Subject to the petitioner mention.
Automatically go out.
Liberty to the petitioner to mention.
नाम बोल दीजिए. Grateful.
I could not apprise on that day itself. Lord, the copy was served.
In that matter,
11:15, my client informed that the copy has been received by her. Immediately, I came before the Honorable Division Bench. The matter was over. I could not assist, Lord. I must be candid. But, Lord, I pray before your lordship, kindly keep it. Lord, it's not that, Lord, they will, Lord, they can, Lord, comply. Lord, we all know what will be the fate of this. Lord, let that report be come before your lordship. Lord, kindly.
Enjoy the stay.
But it's not me who is enjoying this stay. I am the petitioner, Lord. I want demolition. Lord, that's why I approached before this honorable court. The order was passed in way back January 2024, Lord. A building which is totally unauthorized, no sanction plan, not even for the ground floor. Lord, we all know, Lord. I visit before your lordship. Kindly do not take me amiss, Lord. Kindly keeps the matter in the list. Lord, taking in a view of division bench order, Lord, let Mr. Banerjee comes with a report. We all know what will be the fate of, Lord, this regularization prayer. Kindly, Lord, I visit before your lordship. This person is running pillar to post, Lord, since this is the 4th round of litigation.
Mr. Mukherjee, what can I do?
Lord, I am not, Lord, standing in the way of the division bench. What I, Lord, proposes before your lordship that let the corporation take the call and report before your lordship. Kindly do not, Lord, matter go out of list. Kindly, Lord. It's my
You
request.
take your decision when.
That's why,
When
Lord.
will you take your decision?
The outer limit is 4 months. They can already 1 month
They'll
lapse.
never do it.
Decision to be taken by the commissioner, my lord, here. So commissioner has to take some time.
Keeps it after a month, my lord. I am ready, my lord.
House
It's
of the
not.
petitioner is also unauthorized construction, my lord. I have filed on one writ application, my lord. That order was passed.
At the request of the parties, let this matter be listed after 4 weeks.
I'm extremely.
After?
4 weeks. See Mr. Banerjee if he can come up with.
So far as commissioner is concerned, I think it will take some time.
4 weeks.
Commissioner, I will type.
4 weeks, my lord. It's
4 weeks.
Because commissioner is going to make the hearing.
Mr. Banerjee, your
Our
commissioner has
commissioner-
not come from some other planet.
No, not that. Not that. But still, for that reason, my lord,
He has to discharge his statutory functions. That's what he is doing.
he have to completely demolish.
it's
That
not
is-
a
that
question
will be
of
the fate.
demolition.
That I know.
Today, we are not
That I
concerned.
know that he will be the fate. I have submitted in the division bench.
All
No,
that he needs to do is decide the regularization application, which you know what it will be.
I have told you the division
So
bench.
this can be done within a week also.
Within a week also, but actually,
So
commissioner is
please
going-
use your good offices to get this work done. Let's have it after a month.
8
I'm
weeks,
ready.
my lord, then 8 weeks.
30th July, 6 weeks kar do. 800,
6 weeks.
6 weeks.
I'm grateful. I'm extremely grateful.
13th August.
13th August.
August.
Oh, 13th
We'll
August, I will
see.
থাকবো না। Then, my lord, let it be 17th August or
Sev-
12th August in any manner.
17th August. 17th, not a Thursday, no?
No. It is not a Thursday. No.
Yes, it is.
Yes. Then
Okay.
16th.
See, it's a holiday. When do you want? 12th?
12th.
12th
21st.
August? 12th.
I'm grateful.
21. 21, my lord.
No, not
12th
21.
August. 12th August.
12th
12th August.
Both this matter, my lord, 4 and 5. I'm grateful.
এটা 12th August.
May it please, your lordship.
my lord, the petitioner has, my lord, claim, my lord, a family, my lord, the pension with regard to, my lord, the regulation 25B of, my lord, the concerned rules, that is of Kolkata municipal regulations rules. My lord, before, my lord, I start troubling your lordship with the facts and circumstances of the case, my lord, kindly take the trouble to, my lord, record certain relevant dates, which is, my lord, required, my lord, for the purpose of adjudication of this.
Yes, sir.
Am I brief now? Now, my lord, on 30th September 1985, my lord, one Haralal Das, who was in service with the KMC, have died.
30th?
30th September 1985.
Yes.
Then, my lord, on 1st of October 1985, the pension payment order was, my lord, issued in respect of the wife of the deceased employee of that person. 1st October 1985. My lord, the wife was, my lord, given pension with respect to, my lord, the service rendered by his deceased husband. Thereafter, my lord, that is the family pension. Thereafter, my lord, 23rd of November 1985.
Yes.
The wife was, my lord, given a compassionate appointment in because her husband has died in harmless category while in service. That date is on 23rd November 1985.
Yes.
Now, my lord, in pursuance to, my lord, that appointment, my lord, the wife of the deceased employee had, my lord, actually enjoyed both the thing. My lord, the family pension of her husband as well as, my lord, the salary, which was, my lord, the outcome of her service. Now, my lord, if your lordship kindly take note of the date that on 31st October 2010, thereafter,
Yes.
the wife of the deceased employee, my lord, had superannuated. 31st October 2010.
Yes.
Then, my lord, on 22nd February 2013, that is, my lord, 3 years after, my lord, the wife of the deceased employee superannuated, she have died. 21st February 2013.
22nd or 21st?
22nd February. 22nd February.
21st February it is written. Petitioner type, mother of
Yes,
petitioner type.
21st.
February.
21st. I'm sorry, madam. I'm sorry.
As per the list of dates that.
Yes, that is there. It's not disputed. 21st February. So, my lord, it is relevant to point out, my lord, from 1st November 2010 to 21st February 2013, that person, that the wife of the deceased employee have enjoyed both the pension, her husband pension, that is a family pension, and her own pension. Thereafter, my lord, after the death of her of the wife of the deceased employee on 21st February 2013, situation arises, my lord, to consider whether, my lord, the family pensions, that was actually, my lord, the 2 pensions, that was all along the way that has been given by the authority, to whom it shall be based. Now, my lord, the concerned regulations of the Kolkata Municipal Corporation, my lord, stipulates, my lord, the disbursement of the family pension to 2 special category. One is, my lord, the disabled child left behind by the employee, and secondly, my lord, the unmarried daughter above the age of 25 years till she remarries, died, or my lord, these are the category. So, my lord, there are 2, my lord, regulations that, my lord, operating the force. 25A of the concerned regulation says that the disabled child are entitled, and on the very that year where, my lord, 25B, another regulations, my lord, that has been incorporated, my lord, stipulating, my lord, the unmarried daughters are entitled. So 25B is the provisions by virtue of which, my lord, the petitioner is before your lordship, my lord, claiming, my lord, the family pensions to the unmarried daughters. Now, my lord, if your lordship, my lord, kindly turn to 25A, the first regulations, which my learned friend, my lord, in the form of an affidavit, my lord, that has been filed, relied heavily, saying that 25A, my lord, debars, my lord, the petitioner to, my lord, the claim same benefit under 25B. First of all, my lord, let us see whether 25B or 25A are in harmonious with each other, or, my lord, those are in conflict with each other. Now, 25A is appearing.
Just a minute, sir. This is
page 19 of the writ petition.
Page 19 of the writ petition or reply? Sure, their reply.
Lordship, page 9 of our report.
I'm sorry, my lord, I'm sorry.
Of the circular which we are referring.
Page 9.
First of all, my lord, I'm placing 25A, that is, my lord, produced by the respondent.
By the corporation, page 9, right?
Arey bhai, dao na bhai.
25A.
25A, my lord, that
Children
is.
of a KMC employee who is suffering from any disorder, right?
Yes, yes. Now, my lord, kindly first of all take note of the date of this, my lord, notification.
Yes.
This has been, my lord,
22nd.
day of February 2008.
Yes.
Now, my lord, this is a delegated piece of legislature, my lord, where, my lord, the corporation is empowered to, my lord, make rules in accordance with law. Now, my lord, I am placing this. The death cum retirement benefit here under Kolkata Municipal Corporation had generally been in line with those of the state government in marginal differences. With the restructuring of pay rule based on 1510 AICPL, the pension rules were also restructured on the same basis. But the amendment made by the state government in pension rules, liberalizing some provisions of the and deliberalization some provisions have to be so far been adopted by the KMC by way of a modifications of the regulations, though provisions exist in regulation 48 of the KMC employees DCRB regulations 1982 for taking such action with the approval of the corporation. To remove the disparity of the matter was thoroughly examined and proposals submitted before Mayor and Council for approval to enable KMC to take up the matter for approval of the corporation. To Mayor and Council in its meeting dated 15 September 2007 approved those proposals and recommended to place the same before corporations for approval. The corporation in its meeting dated 26 September 2007 approved the recommendations of the Mayor in Council dated 15 September 2007 for modifications, amendment of the pensionary benefits of the employees of the KMCs as follows. Number one, to amend regulation 12.2 of the KMC employees DCRB regulations to effect that all kinds of authorized leave other than extraordinary leave without pay shall come as service qualifying for pension. Period of extraordinary leave without pay granted in the medical certificate shall count as qualifying service. I am speaking that, my lord, portions because that is, my lord, not the issue in dispute. Now, my lord, if your lordship straight away turn to, my lord, page 9 of that affidavit. That is, my lord, 25A.
Yes.
Your lordship had got it, my lord, it appears under sub-regulation 7.
7.
Yes.
A new regulation.
A new regulation, that is regulation 25A, shall be inserted in the said regulations for providing the benefit of admissibility of the family pension to physically or mentally crippled child of KMC employee for life as follows. 25A, children of a KMC employee who is suffering from any disorder or disability of mind or is physically crippled or disabled also render him or her unable to earn a living even after attainment of the age of majority, that is 25 years, for the purpose of admissibility of the family pension. Family pension may be sanctioned subject to fulfillment of the following conditions. Now, my lord, I pause here for a moment, my lord, to indicate, my lord, the word may be sanctioned, my lord. Now, my lord, I need to, my lord, compare these provisions with the 25B because, my lord, it is, my lord, the contention of the respondent authorities that 25B, which, my lord, I'm going to show to your lordship subsequent to this, is not applicable because 25A is there. Now, my lord, let us see what is the language of 25B and what is it has actually objected.
You want to read further or you have read it?
My lord,
25A, do you want to read any further?
It's not required because, my lord, the entire thing is there. Other
That's why I'm
parts,
asking you.
yes, 25 this much, my lord, I need to, my lord, at this moment need to show to your lordship.
Yes.
Now, my lord, 25B is, my lord, appearing as page 23 of the writ petition. So, my lord, first of all, my lord, kindly take note of, my lord, the date of these regulations. That is on 28th December 2008. So, my lord, the reason for which, my lord, I am, my lord, making this, my lord, to be specially emphasized because, my lord, at the time of, my lord, passing of this 20th December 2008 regulations 25B, 25A was already in existence.
Which page, sir?
And that is at page 23 of the writ petition.
23.
23, your lordship. Well, annexure P5. Pagination?
Yes.
Yes. So kindly take note of the date of that regulations. 20th December 2008, my lord. That is the same year where, my lord, in the month of February 2008, the earlier regulations, that is 25A, which, my lord, I have just shown to your lordship, has been passed. So, my lord, while, my lord, passing these regulations, my lord, the authority concerned was aware of the fact that 25A is in existence. And there is, I shall, my lord, indicate that from the regulation itself, there is no indications that these regulations, my lord, intended to, my lord, superseded by 25A or will act in conflict with 25A, nothing. So, my lord, first of all, my lord, let me place it. Paragraph number 2, from paragraph number 2, I am placing, my lord. The corporation in its meeting dated 26th May 2008 approved the recommendations of the Mayor in Council dated 25th April 2008. Accordingly, the Kolkata Municipal Corporation Employees Death Cum Retirement Benefit Regulations 1982 be modified as follows by inserting Regulations 25B under Regulations 25A. 25B, eligibility of the divorced, widowed, unmarried daughter for family pension beyond 25 years of age till their marriage, remarriage, or death. The benefit of family pension shall be extended to the divorced, widowed, unmarried daughter of the KMC Corporation employee pensioners even after her attaining the age of 25 years till her marriage, remarriage, or death, subject to the condition that the benefit is not admissible when the eligible daughter has an income exceeding 2,600 per month from employment in government, semi-government, statutory bodies, corporations, undertaking, private sector, self-employment, etc. So, my lord, I'm again pausing here for a moment. My lord, I'm praying before lordship to, my lord, take special cognizance of the fact the first line, it starts with the benefit of the family pension shall be extended. So, my lord, there is an indication, my lord, in the regulation itself that it does not in any manner whatsoever, my lord, has gone on to, my lord, deal with the 25A or, my lord, to propose to, my lord, create a situation which will be in a conflict with 25A. So it is an extension. So, my lord, that is the reason, my lord, for which, my lord, I have shown to your lordship, my lord, the word used in the 25A, that was, my lord, a may. And here it is shall extended. So, my lord, in the report, I shall, my lord, indicate, my lord, the affidavit, my lord, that has been taken out by the respondent, they say that I should have challenged the 25A. That is about the stand, my lord, taken by the respondent authorities. I, my lord, make it very clear that I do not intend to challenge 25A because that is not standing in my way. Because 25B is, my lord, the regulations by virtue of which, my lord, I am claiming my independent right. And, my lord, there is every occasion, my lord, to, my lord, go through the languages used by the authorities wherein, my lord, it was not intended to be in conflict with each other. Now, let me see, my lord, what was the impugned order that was assailed before your lordship. My impugned order, that is appearing at page 31 of the writ petition, the impugned order.
Page
31, my lord, the last annexures. This is one of a peculiar kind of impugned order, my lord, wherein, my lord, in the facts of the case, when, my lord, this benefit under 25B was, my lord, claimed by the petitioner, the first time, my lord, the respondent authority found that, my lord, the other disabled child of the same employee was, my lord, was entitled to, my lord, the family pension of both the parents. So, as I have, my lord, initially indicated that there are two services. One was, my lord, the husband of the wife, my lord, who has, my lord, died in hardness categories, and during thereafter, my lord, the wife was appointed on a compassionate ground. Thereafter, my lord, she had retired, so she had enjoyed both the pensions. So thereafter, after her death, this situation arises. Now, my lord, I am placing, my lord, the impugned order as a whole because there are certain conflicting statements on the basis of which, my lord, it is required to be placed. I am placing that before your lordship. Factual matrix leading to the present case is the husband and wife were the employees of KMC. After the death of the husband of the KMC employee, the said employee was getting family pension. After the said KMC employee retired from KMC service, she was in receipt of family pension, both arising out of the death of her husband and one for herself post-retirement pension. That is, my lord, which I have, my lord, stated.
after the death of the female KMC employee, son being crippled, suffering from disability, and unable to earn livelihood, is in receipt of the family pension arising out of the death of the female KMC employee. Now, the unmarried daughter of both the male and female employees has come up with a prayer for family pension arising out of the death of the male KMC employee, claiming herself to be unmarried daughter of the both male and female employees of KMC. It emanates from the notes of the administrative department that disabled son is already getting pension arising out of the death of the KMC female employee. In the above scenario, we have to ascertain whether unmarried daughter can be entitled to family pension in the given circumstances. The concept of family pension draws its provenance from the rules governing the conditions of service of a government employee. There is no denial of the fact that in case both wife and husbands are governed by the provisions of pension rules, the surviving child or children shall be granted the two family pensions in respect of the deceased parents. A family pension is payable to the unmarried, widowed, divorced daughter above the age of 25 till she marriage, remarriage, or started earning their livelihood, whichever is earlier. If the deceased government servant pensioner has survived by any disabled child, the widow, divorced, unmarried daughter will be eligible to receive family pension only after the turn of the disabled child. So it says, my lord, the petitioner will have to wait till, my lord, the disabled child, my lord, finishes its, my lord, entitlements, the turn. So, my lord, what is, my lord, suggesting that 25B will not be in operation when 25A is in operation. So, my lord, this is what, my lord, if I could, my lord, most humbly indicate, this is, my lord, a creation among the class, which is not permissible. And even, my lord, I need not go into, my lord, assailing that notifications, because that is, my lord, the contention of my learned friend. I need not. I make it very clear that this is not in conflict with each other. This has to be read in harmonious with each other. This has been extended.
How do you read harmoniously both the?
Because, my lord, 25B.
Please tell me, how do you read it harmoniously?
Because, my lord, 20
is your understanding of the notifications.
25B, my lord, does not say to, my lord, stand in conflict with 25A.
How do you read it, sir? I'm just asking you, how do you read both the notifications together?
Both should, my lord, go, because both are, my lord, dealing with the same class.
I'm asking you a question. You're not answering my question.
My lord, I'm sorry, my lord.
If you read both the notifications, what is your reading? That the disabled child and the unmarried daughter both are eligible?
My lord, at least, my lord, on plain reading of these regulations, my lord, the authority, my lord, did not, my lord, propose to make any conflicting my lord, stand of the entitlement of those two categories. Because, my lord, 25B, my lord, if I, my lord, most
saying that the disabled child should not get or should get?
Should get.
All right. You should also get, he should.
Yes, my lord. That's why, my lord, my point was very.
I'm asking. What are you trying to say? So the provision of 25A, which actually entitles first the minor, second the disabled, and third the unmarried daughter above the age of 25. I think that is how we are supposed to read it. But your reading is, no, it can be divided into all three.
At least, my lord, to the best of my understanding, the language of the statute did not say it is shall extend, my lord.
Also very clear to the extent that if there's a minor child, then the first entitlement is to the minor child.
My lord.
Till the minor attains the age of major. And then the disabled child will come into play. He would be entitled for it. And once the disabled child is no longer there, then the unmarried daughter above the age of 25 will be entitled for it. So that is how the two notifications read.
No, my lord, if I might most, my lord, respectfully indicate, my lord, 25B, my lord, subject to conditions, my lord.
No, I'm just pointing it out to you that it is not only that the disabled is entitled to the first family pension. There is a clause which says the minor is the first person who's entitled.
Yes.
The minor is entitled in case the minor attains majority, then the disabled son is entitled,
Yes.
and then the daughter, the unmarried daughter, aged 25 years is entitled. This is how it is.
And
So
this
to-
is how, my lord, if I could, my lord, most respectfully indicate that this is how, my lord, the respondent is contending.
This
Now,
is how the response.
And my lord, this is how, my lord, if these are to be, my lord, based upon, my lord, the regulations, my lord, that is, my lord, governing the field.
Either you could have challenged the regulation.
That's I have made it
Because
very
there
clear,
is
my lord.
there is no provision where it can be divided.
That is, my lord,
There is
my
no
lord, quote on
provision
before
where it
lordship.
can be divided because 25B itself reads that your entitlement is only after the decedent ceases to.
No, my lord, if your lordship, my lord,
That
kindly
is how it reads.
take the trouble to, my lord, read the relevant portions once again of
These
25.
circumstances are supported by the pension rules, page 14, your lordship, that I have annexed. This
You
has
see-
not been
wait, wait.
challenged.
Tanush, madam, wait, Miss Dasgupta, your turn will come.
So, my lord, 25B, my lord, if your lordship, my lord, kindly take note of
Yes.
25B, my lord, the language used.
Yes.
And, my lord, the specific incorporations of a particular word shall extend to, my lord, possibly, my lord, according to my lord, understanding, has never, my lord, intended to, my lord, indicate a situation that 25B will only be made operable after 25.
Yes, that is what it is, page 32. If the deceased government servant pensioner has survived by any disabled child, the widow, divorced, unmarried daughter will be eligible to receive family pension only after the term of the disabled child.
No, this is, my lord, their order. This is, my lord, how, my lord, the respondent authority sees, my lord, these regulations. So this is the order impugned before your lordship. I am assailing this because this is possibly, my lord, a wrong understanding of both the regulations by the authority. This is the order, my lord, which I am challenging. On the ground that this has actually, that notification in question have actually never meant to, my lord, contemplate a situation like this. This is an unique case wherein, my lord, the family consisting of both category of childs. There are, my lord, disabled childs as well as, my lord, the unmarried daughters. Now, my lord, this is the reason for which, my lord, both these regulations are, my lord, required to be tested, whether they are, my lord, standing in conflict with each other. And now, my lord, the impugnator, my lord, which your lordship had, my lord, just indicated, that is, my lord, I am assailing on the primary ground. First of all, my lord, I shall, my lord, take an endeavor, my lord, to indicate what is the word extend means, because that is, my lord, appearing at the, my lord, the body of the 25B regulations, my lord, on the basis of which, my lord, I am claiming right before your lordship.
Yes.
My lord, the word extend, my lord, the Supreme Court have got the occasion, my lord, to deal with that meaning of that word. I am referring to, my lord, a judgment reported on 1989, supplementary one SCC 487. 1989. হ্যাঁ দিচ্ছি আরে এই জাজমেন্টটা কপি দাও জজে কপি দাও 1980 আমার কপি দাও মানে paragraph 14 of that judgment.
Sir, please come to page 25 first. Of your regulation 25B. I think that will help you in understanding 25B.
Man.
Your own regulation on which you are relying on. Page 25.
My lord.
Number 6. On receiving the application
yes.
along with relevant documents and affidavit as stated in para 5, so and so shall prepare a pension papers for sanctioning family pension in the form prescribed by the Calcutta Municipal Corporation, so and so, and the sanctioning authority while forwarding the proposal for allowing family pension for life to any such daughter. Department shall satisfy himself about the genuinity of the claimant. Now, this is the relevant. It should be ensured. Read it, sir. It should be ensured that there is no other recipient of family pension, which is minor son, daughter, physically, mentally crippled daughter in the family. Now,
so my lord, this is, my lord, appearing. No, my lord, I shall, my lord,
what does it mean? That when the claimant, which is you, who's applying for the family pension, has to be sure about the fact that there is no other person in terms of regulation 25A, which deals with minor son, disabled son or daughter, nobody is there, then you are entitled. The regulation itself 25B stipulates this clause and makes it very clear. You should read the entire regulation.
I've read that, my lord.
You have read this?
Now my question.
Have you
Yes,
read this?
no, no.
Have you
I've-
read this
I've-
line?
No, I have missed it.
Have you read this line, sir?
I have missed it, my lord.
If
I
you have
should be
missed it, then you
No, but then, my lord, even, my lord, if your lordship, my lord, kindly allow me to, my lord, only indicate that, my lord, the parent portions of the regulations, my lord, that is, my lord, these portions is standing in conflict with each other with regard to the fact that, my lord, the original right, my lord, that is arises from, my lord,
come
the
to
first part.
argue a matter, you don't even read the regulation completely.
No, my lord, I have actually, this is portion, my lord, I must be candid enough, my lord, to, I have missed it, but, it has to be tested, my lord, whether, my lord, is standing. These are, my lord, the conflicting provisions, because, my lord, 25.
Conflicting, sir. There's a clarification issue. Now, when I read it, then also you're saying it's conflicting.
No, my lord, then 25B, my lord, must make a sense of, my lord, saying that
25B is
shall
making
extend.
sense, sir. 25B is making sense. This is how you're supposed to fill the form. These are the methods. And this is the declaration which you have to give, ensuring that there is no minor son, there is no disabled child. Please pause for a minute,
That must have
read it again, think about it, and then you make your submissions.
So, my lord, if I could, my lord, only submit before lordship that these portions of, my lord, the regulations is actually, my lord, standing in conflict with the, my lord, the parent portions which has actually given the right. My lord, then shall extend, my lord, that what, my lord, must have been, my lord, used, because extend, my lord, shall always indicate that something is in existence. Now, my lord, that extend has to be, my lord, take a reference to the 25A. So, because that is the only provisions, my lord, that was in existence at the time of passing of 25B. So, my lord, there has to have a, my lord, legislative competence in, my lord, using the words, my lord, in a regulations. Shall extend, my lord, shall always, my lord, denote to, my lord, extending some benefit where that is already in existence. So, my lord, it has, my lord, nowhere, my lord, it has, my lord, stand in conflict with 25A. So that is, my lord, the primary portions, my lord, and that is the reason for which, my lord, my endeavor was to, my lord, indicate to your lordship that extent shall always indicate that something is in existence. So it has never stand in conflict with each other.
Yes. What else?
So, my lord, I shall be, my lord, first of all, my lord, indicate that the word of the extent that has been defined by, my lord, the apex code time and again, my lord, the sum and substance of, my lord, the observations is that must be, my lord, something which is in existence, then it can be extended. So, my lord, 25B, my lord, has actually extended the provisions of 25A. That is, my lord, on the face of it, my lord, does not, my lord, stand in contrary to, my lord, what was there in 25A. So that is, my lord, my primary submissions with regard to the fact that, my lord, my independent right under section 25B is, my lord, arises out of that, and that is not in derogations with 25A. So that is, my lord, my one part. And secondly, my lord, I must be, my lord, candid enough to, my lord, indicate to your lordship that there is, my lord, the creations of the class among the class is, my lord, not required to be. But the same question, my lord, has come up before your lordship in a larger bench, whether, my lord, that unmarried daughters are entitled or not. My lord, I am, my lord, placing that larger bench judgment.
We are not on the fact that unmarried daughters are not entitled.
But there are occasions, my lord.
We are only dealing with, if I'll see your judgment. I'm not saying I'm not seeing your judgment.
But it's my endeavor, my lord, to, my lord,
I'm
impress
just-
upon your lordship.
No, you're impressing upon me. I'm just saying that there's a system in place. Nobody is saying that the unmarried daughters aged 25 years and above are not entitled. We are not on that. That's not the proposition which this court has to see. The entitlement is there. Whether they are entitled above the disabled child is something which we are seized of.
Yes.
So if this judgment supports that contention, you show it to me.
I'm trying to show that, your lordship. 2023 SCC.
Yes.
এটা দাও
Tenancy after.
You have handed over one judgment, sir.
That is, my lord, with regard to, my lord, canvassing that extension shall always indicate that something is in existence, then it can be extended. My lord, paragraph 14 is, my lord, the relevant portions of that judgment. If your lordship take the trouble to.
What are the facts? What is the conceptus of this petition?
This was, my lord, when, my lord, the Supreme Court had got an occasion, my lord, to interpret a word extension appearing in a lease in the conceptions of a tenancy land laws in Calcutta.
It's not relevant, sir.
It's not relevant, but only that's why, my lord, I'm not so much because your lordship is aware of the fact that extension has always impliedly indicate that something is in existence. So I am only for the purpose of, my lord, canvassing the my lord, the meaning of the word extend is, my lord, I'm placing this.
Not relevant.
It is 2020. Now, my lord, I am relying on 2023 SCC online Calcutta 1546, my lord. This is, my lord, a larger bench reference.
Yes. Yes, sir.
Yes. My lord, paragraph number 1 is, my lord, the reference, my lord, that has been, my lord, reproduced. I am placing that. I'm placing, my lord, the relevant portion. Whether the benefit of family pension can be extended to unmarried widow daughter of an employee who superannuated or the died prior to coming in force of the death cum retirement benefit scheme 1981.
We are not in conflict with
Yes.
this proposition.
No,
We are
but
saying
the certain- no,
you are
certain-
entitled.
I
This
understand.
court is not saying that you are not entitled.
But certain propositions, my lord, while dealing the dispute in hand, that portions, my lord, the honorable larger bench, my lord, have got the occasion to see how, my lord, the right of an unmarried daughter, my lord.
The right is, who's questioning the right of an unmarried daughter? I'm not questioning the right of an unmarried daughter. This proposition is a well-settled proposition. Nobody is questioning this
No,
proposition.
but the situation arises.
The situation arises where the rule is first minor, second disabled, third youth.
So, my lord, that portion, my lord, if I, my lord, most, my lord, humbly indicate that portions, my lord, that is, my lord, on the basis of, my lord, the arrangement of the word of 25B, because, my lord, 25A was already in
25B
force.
itself gives a clarification to you to file an affidavit whereby you will indicate that none of these are there, and then you are entitled.
Yes, that's the procedural requirement, my lord, that has
That
been
is
taken
the
care of.
procedure which I just read out to you in paragraph 6, which
That's
you
right.
have missed out.
My lord, the reason for which, my lord, I'm showing this, my lord, judgment is, my lord, to see. Well, now in the present case, my lord, if I, my lord,
You can show it. I'm not
situation
saying,
is
but this is not the issue at hand. We are not dealing with. We are not
now
saying.
25A and 25B, the
We are both
25B
on,
says.
sir, me and you, we both are on the same page as far as the entitlement of an unmarried 25-year-old daughter is concerned. We are not questioning it. This court is not saying that you are not entitled.
The priority of entitlement, that whether I should
show
come, my
some
lord, after 25. Then, my lord, if I could, my lord, advance this argument to your lordship, my lord, then the entire purpose. Now, my lord, 25A and 25B, my lord, should be stand on the same footing, my lord, to, my lord, deal with the constant, my lord, that is being faced by the family members of, my lord, the deceased employees. Now, my lord, the object and purpose of, my lord, the enactment of these, my lord, had there been a situation, my lord, that the 25B, my lord, has been made a part of 25A. Now, my lord, if, my lord, the competent authority, my lord, who are empowered to, my lord, make these regulations, my lord, feel it proper. Because, my lord, even when, my lord, 25A was promulgated, the situation of 25B was already there. But somehow, my lord, the respondent authority, my lord, feel like, my lord, to, my lord, incorporate 25A first, then, my lord, after 7 or 8 months of the same year, 25B. Now, my lord, there was, my lord, these categories, my lord, that has been created by virtue of these regulations are of a homogeneous in nature. They have got, my lord, some equal and similar constraint due to which, my lord, these extensions, family extensions has been extended. Otherwise, my lord, as your lordship had already indicated that the provisions was primarily on a different, that is those childs below 25 years. Now, these are two, my lord, special categories. There should not be any distinctions. Had that been, my lord, created by this delegated legislature, that should have been taken care of. The other aspect, my lord, there should be a directive principle of state policy. I believe, my lord, this has to be taken care of by treating both of them as a homogeneous class. So that is the reason, my lord, I'm, my lord, placing this judgment. I understand, my lord, 25B, my lord, should have been, my lord, a part of 25A, and both should be, my lord, equally entitled to this benefit. That is the reason, my lord, I'm placing this. No, there are, my lord, that is absolutely factual. The other persons must have given a NOC, my lord, who are crippled child, and that is lying with the authority with regard to, my lord, the granting of this relief to, my lord, the petitioners. That is factual, but since, my lord, your lordship is actually on the point that whether 25B is to be made operable only after exhaustions of 25A. Now, my lord, my endeavor before lordship would be, my lord, to indicate, but possibly these are of the same class. So that is why, my lord, I have, my lord, placing this judgment before lordship. So then I may be, my lord, then if required, my lord, to, my lord, advancement argument on the fact that 25B, that subclause, my lord, is actually nullity in the eyes of law because of the fact,
Can
my lord,
make
that is proposing a
Any argument you want to, sir?
that is, my lord, proposing a distinctions between this class.
Yes.
So 25A and 25B, my lord, should be, my lord, equally, my lord, made applicable to all the categories falling under these regulations. That is my argument, my lord.
Done.
Yes, and the relevant portions, my lord, I'm just not bothering your lordship, only indicate paragraph number 26 and 27 of, my lord, the larger bench reference, my lord, is have gone on to deal with. Although, my lord, the category was not same, but court had got the occasion.
Read it. You should not
my
feel
lord.
that you were not heard.
No, my lord. From the, I'm placing, my lord, paragraph number 26 of the judgment.
Yes.
From the memoranda as above, it is clearly explicit that the legislative intent was to extend the benefit of family pension to unmarried, widowed, divorced daughter of an employee who retired before or after 1st April 1981, or to unmarried, widowed, divorced daughter of a family pension. So, my lord, in this case, there was a cut-off date. My lord, it has been, my lord, mandated that beyond that cut-off date, certain benefits were not admissible. No, my lord, court had got the occasion, my lord, to deal with, my lord, the Supreme Court judgment saying that there has to, my lord, a homogeneous treatment, and there should not be any class among the class. So the class was created like from those who have retired prior to 1st April 1980 and those who have retired thereafter. In such premises, the memorandum dated 1st November 2010 should not stand in way of extending such benefit in the absence of any express provisions therein restricting or affecting the benefits. Socio-economic justice stemming from the concept of social morality, if passed into service, the memoranda granting social security or livelihood to the aforesaid classes of women by providing family pension should be construed liberally. Some isolated terms in the memorandum dated 1st November 2010, providing person to living employees or the widows, in our view, cannot restrict the beneficial provisions contained in the memorandum as above. So, my lord, this is, my lord, the relevant portions because it has also, my lord, got an occasion to deal with that there are certain restricting provisions appearing on the memorandum. So, my lord, court had got the occasion, my lord, to deal it in the manner that socio-economic, my lord, structure that was, my lord, the object that must be achieved. My lord, cutting those restrictions.
All right.
Therefore, we answer to the reference to the extent that the benefit of family pension can be extended to unmarried widowed daughter of an employee who superannuated or died prior to coming in force of the death cum retirement benefit scheme 1981, which come into effect on and from 1st April 1981. So, my lord, this is, my lord, the relevant considerations before, my lord, the larger bench. They are also, my lord, a restrictions clause, my lord, the court, my lord, in its prudent held that those are not to be, my lord, upheld. So that's why, my lord, I'm showing this.
What else? Yes.
Chief, I'm led by Mr.
Hello, my learned
Let her do it.
I adopt my learned friend's contention, my lord. I believe that is
Let Miss Tanushri Dasgupta do it, Mr. Nayak.
because he has argued on my behalf. We are not, my lord, saying that his claim is not, my lord, entertainable always, but when if a disabled child is there,
Mr. Nayak, let your junior do the matter. Huh?
I am just allowing her to argue only
Let her assist the court.
one paragraph, my lord. I am placing.
Mr. Dasgupta, let her assist the court. Yes.
Lordship,
Ms.
lordship.
Dasgupta.
I am obliged to lordship.
Yes.
She is very competent. Let.
Lordship,
Yes.
the point is this is that these circulars which has been relied upon, what my learned friend has not indicated is the pension rules, that which we have also annexed with a report. The extract of the pension rules, if my lord comes to page 14, therein it has been categorically stated 5.3, Roman 3, that the
Slow, Miss Dasgupta, slow. Yes. Which page?
Page 14
Of your report?
of our report.
Yes.
Roman 3, The
Yes.
family pension is payable to the unmarried, widowed, divorced daughters above the age of 25. After all, unmarried children have attained the 25 years of age or started earning their livelihood, whichever is earlier. If the deceased government servant / pensioner has survived by any disabled child, the widowed, divorced, unmarried daughter will be eligible to receive family pension only after the turn of disabled child. So, Your Lordship, whatever circular has come up, this is in compliance or in consonance with the pension rules. The entire submission that has been placed or forwarded by my learned friend here and now before Your Lordship is challenging the circulars, but never challenged the pension rules. So, the petitioner has neither challenged the pension rules nor challenged the circular. Despite of the situation, crux of the pension rules, this point has this paragraph or this issue has not been challenged by the petitioner. So, having not challenged the subject matter, the petitioner in the relief has only sought for the rejection of the impugned order passed by the department concerned. Apart from this, Your Lordship, the minor child, the disabled child, when received the family pension, the petitioner never objected. The entire scenario went, and in the 2013, the mother of the petitioner expired. Today, the first representation was placed on 2023. So, therefore, Your Lordship, after a lapse of 10 years, though Your Lordship, I admit regarding the ground of pension, the delay might not be a criteria for an embargo, but in this particular case, when the disabled child was receiving the pension, first of all, there is no bar. That is the circulars which my lord has amply looked into. Apart from this, Your Lordship, the petitioner never came forward and objected. At that point of time, had it been the situation the petitioner has challenged, then the entire scenario would have been different. And apart from this, the circulars, neither the circulars nor the pension rules have been challenged. So what my learned friend is indicating here is challenging the pension rules, but without the relief. The relief that has been sought for at this juncture cannot be sustainable. That is my humble submission, Your Lordship.
Yes, Mr. Nayak, you want to add
No,
something?
no, nothing additional, my lord. Only we are concentrating on this, my lord, plea.
With your expertise now, you can add something. Yes.
Always, my lord, she has completed what he wanted to submit. Whole thing is this: our claim is still remaining. But after, my lord, after this, my lord, disabled child's tenure, luckily or unluckily, is being over.
I shall, my lord,
That's all.
if I may only
Yes, yes.
indicate that the rule which my learned friend has shown, that is appearing at page 14, is a CCS pension rules. So, my lord, the employee concern is not covered under this. That's why I have not challenged. But the CCS rules, my lord, which your lordship can take note of, appearing at page 13 of the report. It is an extract of the CCA rules. So
Yes.
that is applicable for the central government.
Yes.
So here, my lord, the corporation have got their own death cum retirement benefit rules. So, my lord, I must not look around until unless it is required. I mean, so that's the thing. And, my lord, if my on the other part of submissions of my management, if, my lord, the delay have caused, my lord, me to, my lord, go out of the merit and not on the legal ground, my lord, that is a defined aspect, my lord. I'm leaving it to your lordship.
Take down. The petitioner is aggrieved by the communication dated 13/4. 2024, whereby her application for pension was rejected by the respondent. The case of the petitioner is that her deceased father was an employee of the Calcutta Municipal Corporation. Upon his demise, the petitioner's mother was granted compassionate appointment and was also receiving the family pension. Full stop. Following the death of the petitioner's mother on 21/2/2013, the family pension was being dispersed to the petitioner's handicapped brother. Full stop. The petitioner submits that she is unmarried, dependent daughter of the deceased employee, and is therefore entitled to receive the family pension under the applicable rules. Full stop. Despite making several representation to the respondents, comma, her claim was ultimately rejected by letter dated 13/4/2024, which has given rise to the present writ petition. Learned counsel for the petitioner has relied on rule Rule 25B of the circular dated 20th of December 2008. Full stop. It is the contention of the counsel for the petitioner, Mr. Tilak Mitra. You are Mr. Mitra, right?
Well,
you are Mr. Mitra.
Tilak Mitra.
Mr. Tilak Mitra. That the said rule 25B is in contravention with rule 25A, full stop, and that a harmonious reading of the said rule will entitle his client to the family pension, full stop. He impresses upon this court by stating that the said rule was brought in force in December 2008, while the rule 25A was already in existence since 22nd of February 2008, and that both should be read together, which would entitle the petitioner to the family pension, full stop. This is your submission?
Yes, ma'am.
Learned counsel for the respondent, municipality has filed its affidavit in opposition, comma,
Lordship,
its report, comma, wherein reliance has been placed on the provision of CCS pension rules 1972, full stop. It has been contended that as per the said rule, comma, the family pension is admissible to an unmarried, comma, widowed, comma, or divorced daughter above the age of 25 years, comma, only after all the unmarried children of the deceased government servant have either attained the age of 25 years or have started earning their livelihood, whichever is earlier. Furthermore, the rule stipulates that in the event the deceased government servant or pensioner is survived by a child suffering from a disability, comma, the right to receive family pension shall vest in such disabled child, comma, and the claim of any other eligible child, comma, including an unmarried daughter, comma, shall arise only upon the cessation of disabled child's entitlement, i.e., after the child ceases to be eligible due to death or any other disqualifying factor. Full stop. In addition, the respondent has also placed reliance on circular number CH manager /pen/CIR /010/2007 -0808 dated 22/2/2008, comma, issued by the Chief Manager, comma, Service Records and Accounts, comma, Pension Cell, Calcutta, full stop. The said circular clarifies that the said circular, the clause 25A of the said circular clarifies that in case where the deceased employee is survived by 2 or more children, the family pension is to be initially granted to the minor child in accordance with the DCRB regulation until the youngest minor child attains the maximum eligible age, full stop. Thereafter, the family pension is to be paid to the disabled son or daughter for life, in terms of the applicable pension rules and departmental instruction. Full stop. This court has heard the argument advanced by the learned counsel for the parties and has perused the materials on record. It is not in dispute that the family pension of the deceased mother of the petitioner is currently being disbursed to the petitioner's disabled brother as per the prevailing legal framework, the petitioner being an unmarried daughter above 25 years of age, would be entitled to claim family pension only after the cessation of eligibility of the disabled sibling who is presently receiving the same. Full stop. This court further notes that the circular dated 22/2/2008 and 2012/2008 rather clarifies the position that the rather clarifies the position which has been contended by the learned counsel for the respondent, wherein the Rule 25A makes it evidently clear that the minor will receive the pension. The first pension, the minor will have the right to receive the pension till the time he attains the age of majority, and then subsequently the pension will be disbursed in favor of the disabled child, and after the cessation of the disabled child, the pension will devolve on the unmarried daughter above the age of 25 years. Full stop. The circular dated 20th of December 2008 itself records in page 25 in para 6 that the disabled daughter at the time of making the application will file all the relevant documents and affidavits as enumerated in the said circular, and in that it is clear that the disabled daughter should indicate that there is no other recipient of family pension, i.e. minor son / daughter, physically / mentally crippled son / daughter in the family. The reliance of the petitioner on the said circular is misconceived, as the circular itself has clarified that the unmarried daughter will be eligible and entitled to the family pension only after the disabled child. Full stop. This court, in view of the explicit legal provisions and circulars governing the disbursement of family pension, this court finds no legal infirmity, irregularity, comma, arbitrariness in the action of the respondent authority in rejecting the petitioner's representation, wide the impugned communication dated 13/4/2024, full stop. Accordingly, in view of the aforesaid findings, comma, this court is of the considered view that no interference is warranted in the impugned decision of the respondent, full stop. The writ petition is devoid of merit and is hereby dismissed.
I vote on it.
Much obliged. Great.
My lord, item number 7 to 10, my lord, similar matters, my lord, that Shoika's matter. My lord has been pleased to pass an order, my lord, and last week, lordship can see the my lord's order, my lord,
Yes.
against the self same municipality, my lord.
I have, my only thing is,
Consider.
yes, my only
Lord,
thing is
Pursuant
considering.
to your lord, last
Vacancy.
direction, my lord, in respect of 3 matters, my lord. My lord, the municipality, director of local body already, my lord, asked the petitioner to appear. They appeared in the, my lord, hearing, my lord. In respect of 3
My
matters.
only consideration is adequate vacancy. And if all petitioners apply, my lord, only the consideration would be the vacancy.
Yes, my lord, 10 vacancies are there, my lord. It has been already indicated in my lord's order, my lord. And if your lordship, my lord, allow me, my lord, I have, my lord, corrected it. If your lordship permits me, my lord. Only, my lord, the age and the, my lord, center, school.
You have corrected it?
Yes,
Just-
yes, yes.
Just give the.
Others are same, my lord.
আসেনি কেউ দিয়ে দিন কি করবো রিপ্রেজেন্টেশন না হলে থাকবে না কারোর
ये ऐड कर देना. The petitioner further contents यहाँ पे 6 के बाद 7, 8 will change to this. ठीक है. The petitioner further contends that in similar matters, including WP number 23745 of 2017, WP number 1123 of 2019, WP number 5714 of 2022, WP number 21127 of 2022, and WP number so and so 28275 of 23, and WP number 15467 of 24, comma. This court, wherein this court directed the concerned authorities to consider the cases of similarly situated person. ठीक है, उसके बाद कर देना learned counsel the respondent corporation submit the detail. ठीक है, बस ये एक paragraph है. All right,
Next matter is also the same, my lord.
same one.
I said, I have,
Just one indulgence, I am
You have made
here
the
for the
statement?
old Malda municipality.
Yes. You appear for the,
old Malda.
The municipality.
take Miss Sain's appearance. You have made Yes,
Yes, I am handed over.
So 7 you have done, 8 you have done, 9.
9 and 10 same. Yes.
Give the correction and the dates. Just
Only the-
right on top of the, oh, you have given 7, 8,
I've
9,
corrected
10.
the Milord.
He has made the correction. Just add that one. All right. 10.
10. Well, in respect of 10 Milord, she was appointed in the year 2016 and her service Milord discontinued 2018. That I have corrected, Milord. I have mentioned.
Corrected.
Yes, Milord.
Same order. Same order.
Same order, Milord.
8, 9, 10.
Grateful,
7, 8,
Milord.
9, 10.
Milord, all the matters, Milord, the affidavit service be kept on record. Milord.
Affidavit service taken on record. Same order.
Grateful, Milord.
You will consider the representation.
Yes.
All right.
In fact, Milord, in all the matters, Milord, that Director of Local Bodies, Milord, they have complied the order. Even my Lord's order also. Seven, 8, 9, 10. 7, 8, 9, 10.
8 इसके नीचे ऑर्डर है, इसके नीचे देखो।
Yes, my lord, I am appearing for the petitioner, my lord.
By yesterday, your
I
lordship
am
heard the
appearing
matter.
for some of the private respondents. My lord,
Yesterday, your
each
lordship-
matter and item number 82, self-same, similar, and on the self-same cause of action, both the matter may be taken up together. And what is
Corrected.
interesting, my lord, the petitioner wanted to withdraw the case because he was coerced to file the petition. And she has already written to the Honorable Chief Justice so that her case is withdrawn. And she has made allegation against her. She has also written to the advocate, I did not want to file the case and I was on coercion of my son-in-law. I have to file. So kindly withdraw the case. Your Lordship will kindly see. I think the letter addressed to the Honorable Chief Justice is also in the file. This is, my lord. Yes, my lord. This is the copy. Kindly.
A copy of the said allegations, my lord, alleged document may be given to me.
Lordship will kindly consider. I think the
Copy of the same, because the
yes, I'll
allegation.
give you. I'll give you. Wait.
Already.
The assistant son-in-law coerced her to file the petition against unwanted who are not, she did not ever wanted to do this.
If this is
And-
true, my lord, this is a serious allegation, my lord. Then my petitioner,
The son-in-law is an advocate of this honorable court.
Who's the son-in-law?
My lord, I am just, my lord, I am seeking leave to go through the document, my lord, which is being
This
alleged
is a
about the
letter
fact.
addressed to the honorable Chief Justice
Yes.
and also to the
are-
the learned advocate. I
My
think
lord, I want to see, my lord, I don't have right.
but that's why yesterday I told your lordship kindly see page 29. No signature is there. Your lordship
lord,
asked the petitioner.
Yesterday, I have deposed before your lordship that there is a return document, my lord. This is the return
Kindly
document.
see page 20.
Open the return document.
Kindly see
Yes,
page
this is
29.
return document.
There's the signature of the person.
yes.
My lord, if this
If
can be
your
opened
lordship-
in the court, then I can show that all the documents which I have sent through the post, my lord, those are clearly signed.
This is your client, Purnima Biswas.
Punya
Yes.
Vishwas is my client, my lord. My lord,
Give him
he has a power of attorney holder, my lord. She, and the
Power of attorney was given to the daughter, and daughter was tortured. She was forced to sign on her behalf by the son-in-law. This assistant son-in-law is an advocate of this honorable court.
Give a
My lord, the
give-
copy of the
give a
letter.
copy of this.
Yes, I'll give. Lordship kindly keep this both the matters.
Yes.
This matter and 82, item number 83
Open
together.
that. Where is that?
83.
ওই envelope open করতে বলছেন
Envelope. Open the envelope.
Open that. Show the, is it? Close the envelope, open.
page 29.
This is sent by the lawyer.
Yes.
You are Satyajit Singh Roy.
Yes, I am Shatrajit Singh. First, my lord, first of all, I want to see, my lord, whether any letter which they have alleged that it was served upon me.
Yes,
By the
yes,
Purnima
it was
Bishop.
served upon the learned advocate on record.
Yes,
This is the, your Lordship kindly see, I have the postal.
please show me. আমাকে দেখাচ্ছেন না কেন?
এই যে দেখুন। Court, I have sent it to the court.
কি হচ্ছে আমাকে?
Find it. You will find, you will see.
আরে আমাকে তো
Give-
কাগজটা দেখ।
Give it back to him.
So, Lordship,
Yes,
If your
but
lordship so
we have-
desires,
Yes, yes.
ask the petitioner to produce her before this honorable court and take her person.
This is actually, my lord.
I will set it right.
Yes, my lord. I'm coming to this, my lord.
Yes.
First of all, my lord,
Want to argue today?
my lord, I'm ready to argue. But so far, the petitioner is required to be produced before your lordship
Yes.
because they have been because she was abducted by the promoters, and we have filed. Her daughter have filed.
No. You please bring the petitioner here to the court.
Yes, my lord. I will be grateful. My lord. I must.
My lord, I
And
have
my lordship, I see-
read of
and on
habeas
the next
corpus.
date, my lord, you
Bring
know,
the petitioner to the
this
court.
matter and 83 both should be taken up together because of the
petition
same
are
purpose.
Take down writ petition so and so along with writ petition so and so shall be tagged along. Let this matter be listed along with writ petition number so and so. Full stop. Learned counsel for the, you are for?
Some of the private respondents.
I am for the state respondent, my lord.
Learned counsel for the private respondent has handed over a letter addressed by the petitioner in writ petition number so and so, Purnima Biswas, Srimati Purnima Biswas, addressed to the Honorable Chief Justice of this court.
My lord, before passing the order, my lord.
For intervention and necessary action against her estranged son-in-law, Tapan Roy, advocate practicing in the Calcutta High Court, who she alleges to have committed physical and mental torture upon her and had compelled her to file litigations at his whims and caprice and against her will. Full stop. Learned counsel for the petitioner states that her client has not made any such allegation. Full stop. This court let Ms. Purnima Biswas appear before this court on, give a date, Friday?
My lord, on Friday. No.
I have no problem.
My
On
lord,
Friday?
next, my lord, next Tuesday, my lord. 1 week time may be given, my lord.
Next Tuesday. Why?
My lord, because what I am, my lord, submitting before your lordship, I have already filed one writ of habeas corpus, and that is already
The son-in-law is
Just a minute.
now standing
Just
here.
a minute, sir.
my lord, that is all.
You are the son-in-law.
Yes.
Yes.
You be prepared. Friday.
My lord, the writ of habeas corpus is appearing today before the, my lord, before the Honorable Justice Tapabroto Chakraborty and, my lord, the Honorable Justice Ritobroto Mitra.
So you are saying your Purnima Biswas has been kidnapped?
Yes.
All right, take down.
And
Learned-
that has been the
Learned
officer-
counsel for the petitioner, when this court had asked the petitioner to bring the counsel for the petitioner to bring the petitioner before this court to enable this court to find out the allegation which has been leveled by her against her son-in-law. Learned counsel for the petitioner states that they have filed a habeas corpus writ before. What is the writ number? Habeas
My lord,
corpus petition number.
my lord, this is WPA 44 within bracket H.
H
of 2025,
of 2025, titled
title, my lord, I'm giving the particular entire things, my lord.
Whether there was any FIR lost or missing
just-
diary lost, I don't know.
My lord, this is the item number 4, appearing with Bashanti Roy Paul.
who was Basanti
My
Roy
lord, she is the daughter of Purnima Bishwas. She has filed this,
and your wife?
yes. She
Titled as Basanti Roy Paul versus state.
state. And my lord, this is the cause list.
The estranged son-in-law is appearing along with the petitioner counsel in the present matter and is present before the court. Full stop. Counsel states that Purnima Biswas, though initially the counsel had agreed to produce Purnima Biswas before this court on Friday, but suddenly the council has taken the pretext that Purnima Biswas has been kidnapped.
My lord,
Kidnapped, right?
yeah, I am not, my lord, from the all along, that was my submission, my lord.
Purnima Biswas
Only the
is,
state authorities, police.
My lord, I shall,
where is the FIR lodged by you?
my lord, that brief is in the courtroom number 11, my
Where
lord.
is the FIR, sir?
Why?
You
My
come
lord,
back. You come back after lunch. Come back after lunch.
yes.
Come back with all the details after lunch. We'll have this matter after lunch.
At 12, at 2 p.m., my lord?
At 2 p.m.
Yes.
You come back with all the details.
Yes.
Sorry. Lord, Lordship will kindly take up 83 also because both the cases are suitable.
83, my lord, if this has not been decided, there is no question of,
We will take both the matters together. Don't worry. First, let me set things right.
yes.
As you look.
Grateful.
83 corporation. 83 also corporation, my lord. We went there, but no premises is found.
না ডিএলবি না চলতে পারবে না, কিছু করতে হবে না। 12, my lord, I am appearing for the petitioner, my lord. Yesterday that matter was concluded, but my lord, can evidence substitute.
You keep relying upon these this judgment. Have you seen these judgments?
Yes, my lord.
No, what? Yes, my lord. Which judgment I'm talking about?
Judgment
What? Yes, my lord.
2018 2 CHN,
No.
page 534.
Have you seen these two judgments which squarely covers your case?
Yes, my lord.
Just hand over these two judgments. to him.
Judgment.
Have you seen this?
No, my lord.
This pertains.
Yes. Just now I have seen it, my lord.
What do you
that
mean?
matter-
Just now you have seen it.
Yes. Oh, my lord. It is.
Hey, are you aware of this
No,
judgment or not?
No, my lord. Justice Sina, my lord. I know this judgment.
So why you're not
Yes,
showing
yes.
this judgment?
No,
This
no,
is
no.
all covered judgments.
No, yes, my lord.
Why you take me here and there? Why
But-
don't you straight away
but
come to the
just-
point?
Just.
These are all
But this
arising on the
matter-
same order. These are all 92, pre-92.
392.
This judgment has taken care of the initial date of appointment and the subsequent date of appointment.
Yes.
And then this has been taken up to the division bench. So, sir,
My lord.
are you not covered by this
Kindly,
judgment?
my lord, my lord, that matter is different, my lord.
That's what I'm asking. How is it different, sir?
My lord, that matter depend on the discrimination
That's what
because
discrimination is to the
Yes.
extent that some of them have been given appointment from the date of joining.
date of joining
Wait a
this
minute.
case. This case.
First, hear me out.
Yes.
The classification or the differentiation is to the extent that some of them have been given appointment from the date of joining. Some have been given from a later date.
Yes.
And from the later date, the director local bodies is taking the pretext that they have not done the qualifying service of 10 years
Yes.
and is rejecting it.
Yes.
That is a differentiation
Yes.
that has taken, will you read it? Come back on Tuesday.
He was the advocate requirement. He moved.
No,
the
no,
case.
Read the judgment. Keep it on Tuesday.
Okay.
At least read the judgment so that you don't waste time of this court. Even the research this court has to do for you.
No, yes, but I've read it, my lord.
Then,
That matter was moved on Monday.
then, sir, that differentiation and that classification is over now.
Yes, just difference is, my lord. This matter, 53 employee was approved with effect from date of joining. And this matter, my lord, rest of the 7 employees, 16 were forwarded to the DLB for approval, 53 covered by this matter, and rest of the 7 matter, my lord, approval with effect from the date of approval. Approval granted with effect from the date of, not from the date of joining.
So that's what I'm, did I speak some other language?
Yes.
Am I speaking the language
Yes.
which you are accustomed to or you understand? This is what I am
Can
saying.
you dispose of the matter, my lord?
No, first you read it.
First?
Read the judgment and come. Assist this court.
Yes, my lord.
Assist this court.
My lord,
This
Monday.
is not this court's job.
No, Monday, my lord, this matter.
As a lawyer, you should assist this court.
Yes.
Come back after reading this judgment.
Right. Tuesday.
Tuesday.
Yes, and judgment is the last. Yes, my lord. Tuesday.
Take the details of the judgment.
Yes.
Take the DB judgment also.
I'm good.
My lord, I beg to appear for the petition.
But I appear for the state respondent.
My lord, in this matter, there is some history. Because, my lord, initially when we filed, we were under the impression the matter would become under the heading service matter. Accordingly, we approached the bench. Now, bench, my lord, was of the opinion that no matter has to be heard by the municipality bench, as because my employer is municipality, but my paying salary is the state through director of local board. My lord, we served twice to the municipality. They didn't appear. My lord, my basic case is that initially I was appointed as a tax collector. Subsequently, in promotion, I was promoted as a collecting sarkar. Now, my lord, the one person allegedly got promotion who is much, my lord, below, which is junior to me, he got promotion. Then a resolution called for, I was directed so cause, I explained, then his post, he was withdrawn from his post and was, my lord, posted as a clerk, and I got promotion. But without any reason, my lord, his salary was unchanged. And though I was performing as a, my lord, promotional post, but getting the salary of my earlier post. And my lord, one more thing, with your lordship's, my lord, permission.
Yes.
Initially, when I filed it, at that point of time, my lord, determination was with other bench. So, my lord, some paper is in Bengali. My lord, I prepared a supplementary affidavit annexing the, my lord, translation copy of those Bengali documents, my lord. If your lordships allow me, I can file it, my lord. Because some of the pages are in Bengali, my lord. At that point of time, my lord, determination was, my lord.
First, you show me from this document.
My lord. But kindly come to page, my lord, 28. This is my letter of appointment. Hamol Chakraborty is the petitioner before your lord. The third name, my lord, Samuel Chakraborty, collecting sarkar, date of effect is 3rd April 2000. My lord, then kindly come to page 30. I was directed to so cause because meantime, my lord, another person got promotion who is junior to me. Then I got a so cause, my lord, on 18th December 2019. I replied to the so cause, my lord, though it is in Bengali. In the so cause, my lord, they came up with a case that earlier, my lord,
Page 29 is which page?
My lord, page 30 is the so cause.
So page 28 is your appointment. Page 30.
Page 30 is the so cause.
That's in English.
My lord,
That's in English.
that is so called, but reply, my lord, page 31 is
Reply.
in Bengal. I prepared the translated copy, my lord. I can submit to your lordship. Page টা কত?
Your reply is page 31.
Yes, my lord. Here, my lord, the municipality come up with the facts that earlier I wrote a letter to them where I disclosed that I don't want promotion. But I categorically told them neither it is my signature nor the letter written by me to the municipality.
Now, I'm not able to understand. What are you seeking?
My lord, I am seeking because, my lord, I got promotional post,
Yes.
but they are giving me the salary of my earlier post.
Yes.
The additional money they withholding since 2019. And my lord, the person who allegedly got promoted, he is still withdrawing salary of a promotional post, though he is discharging his service, my lord, as a clerk. That my lord, from the resolution I can substantiate from the municipality documents. It's not a single documents of mine. My lord, then my lord, kindly take my lord page 44. Rather, my lord, 45. There, my lord, it would be something, my lord would get a picture of my case.
Page 45. That she shall.
They have admitted that, however, on my lord, sir, this is brought to your notice that the name of Sri Samuel Chakraborty collecting Sarkar was not incorporated in the gradation list sent by this office number so and so, dated so and so, for the cause based known to them, guard of board. However, on scrutiny verification of record, these may be safely inferred that the gradation list was prepared without due diligence. Now, this office proposed to rectify the gradation list with the incorporation of incumbent's name, Sri S. Chakraborty, that is my lord Samuel Chakraborty, who is petitioner before your lordship, for doing justice in consideration of promotion. Sri Chakraborty has been suffering substantial financial loss, may be appreciated due deprivation. Now, my lord, thereafter, my lord, what has happened? One Sopon Kumar Sarkar was earlier promoted to that post. That your lordship will find out page 47. And he was revoked from his post. That is my letter issued by Senior Deputy Secretary to the Government of West Bengal to the Director of Local Bodies. My lord, first paragraph number 1. Revocation of promotion order in respect of Sri Sopon Kumar Sarkar issued so and so, so and so, so and so. And recovering the withdrawal within next 6 months from the salary of Sri Sopon Kumar Sarkar as the employee is still in service. By way of short deduction from salary of incumbent may deposit the amount in the concerned treasury linked bank through treasury chala. Now, my lord, thereafter, your lordship kindly take. Then again, my lord, I was served with the appointment order. My lord, page 54. My lord, Samuel Chakraborty, designation tax collecting Sarkar, promoted to tax collector, and the my lord, structure of my salary. Then my lord, kindly turn the next page. They have given a calculation that how much money needs to be, my lord, recovered from the then person who was promoted to that post, tax collector, S. Sarkar. They did nothing. Then, my lord, kindly turn the next page, page 56. Here he has been, my lord, demoted to the clerk, my lord, Sopon Kumar Sarkar. Then, my lord, kindly page 58. In the, my lord, may I read it? In modification to this office memo number so and so, dated so and so with annexure A, all concerned are hereby informed that the salary structure of Sopon Kumar Sarkar, tax collector, Old Malda municipality will remain unchanged until further. Though, my lord, I accepted my promotional post. My lord, acceptance was taken by them on 7th February 2024. Though, my lord, it's written in Bengali, I prepared, my lord, a translated copy, my lord. That is my case, my lord. His salary, without any reason, my lord, remain unchanged. Now, my lord, subsequently, I was served with a writ petition that HON'BLE Sarkar filed a writ petition before this court, a Sopon Sarkar, which is, my lord, registered as WPA number 21636 of 2024. My lord, it is running in your lordship's needs, item number 1605. 1605.
1605.
Monthly list. And I have, my lord, also annexed then, my lord, several times I wrote a
What is
letter
he challenging in the writ petition?
regarding his
demotion?
And, my lord, I have written several letters to them. Lastly, my lord, page 66, that is my demand letter on 3rd October 2024. And other, my lord, letters I'm not showing because all are Bengali, my lord, unless I allowed to place these in, my lord, English.
No.
And also, my lord, I attached my salary slip, where from your lordship will find out my basic pay, which has been given to me, my lord, since, because, my lord, my date of appointment is newly promotional post is on 7/2/2024. I'm showing one page to your lordships regarding my salary, page, my lord, 89, my lord, my lord, 90. Kindly take, my lord, right hand side date.
Which page?
Page 90, 190, my salary slip.
19.
90, yes, my lord, 90.
Yes.
Kindly take note of the, my lord, bill date on a right hand side.
Yes.
Top is 28th February 2024.
Yes.
And, my lord, kindly see the designation, collecting Sarkar. Though I was promoted to the post of collecting Sarkar, but, my lord, kindly see my basic. It's supposed to be 52,000. Oh, my lord, I was promoted to tax collector, though my designation is writing as a collecting Sarkar, where I was initially, my lord, got employment. Neither my designation was changed, though I accepted the service, they, my lord, acknowledged that. Despite that, my lord, my salary is that. And his, my lord, despite, my lord, demotion, his salary remain unchanged. And these are not, my lord, my
No, my lord, I am appearing with the state respondent only. No, my lord, the
Respondent is
difficulty
the person concerned, the DLB, right?
My lord, I don't know, because I was under the impression state, but the coordinate bench holds that municipality
The
needs
municipality might be because you are working
because
for the
my
municipality.
salary, perhaps, my lord, state will fund it the money.
My lord,
my
may I
lord,
just
perhaps.
indicate one thing? My lord? Actually, the difficulty arose because the old Malda municipality is trying to bite the same cherry twice. They are now recommending that the other Sopon Kumar Sarkar and got it approved. They provided a wrong list. We sought for a clarification. Till date, no clarification. Now, in the meantime, they are saying, yes, we have done some wrong, admitting to the petitioner. And thereby, the other person has already filed the writ petition. Now, during this pendency and the dicey stand of the municipality, well, we cannot take a call that yes, we are because that position of the Sopon Kumar Sarkar was got approved through us by the municipality himself by giving a wrong list submitted by them. The gradation list has been. That's why we have also focused them that why we need a clarification to that effect. Till now, they are sitting mum. Now, let that petition be tagged together. Let it be decided once for all. Whatever decision will come up, we are also pointing it out. If there is any wrong, that list should be taken care of because the gradation list that they have forwarded.
Have you filed your affidavit in that case?
No, my lord, that is yet to
I am not engaged in that matter.
It has not been taken up.
Not been taken up till date. What it appears from the
because we have been arraigned as a respondent over there. I have been arraigned as a respondent.
So the municipality is now shrugging up their responsibility because they cannot explain why they are forwarded with a wrong this list. So everything has to be before your lordship, so that your lordship may decide. We may act accordingly.
Find out from the record that twice I have served to the municipality. Till date, they are not.
Nobody appeared in that bench also.
That bench also they did.
Nobody appears for the municipality.
Despite, and it is records that I have served. Kindly see, my lord, order dated.
Who's the lawyer concerned? You know, this is which municipality?
My learned senior told one name, but I tried to find out him, but I didn't.
Which municipality is this? Malda.
Old Malda municipality.
There is two.
Hem? Who's the lawyer concerned? You have to find out, sir. Then.
Let one Archio Chakraborty, I told that he used to appear in those Malda municipality, but I tried to find out him, but I didn't get him. My lord. And neither I have a number of him, my lord, so that I can call
My lord,
him.
may I just indicate one issue, my lord? If
my
that
lord, my
writ petition,
help me to
that
that
writ petition.
it would be better.
No.
Sorry?
If my learned senior can contact with the municipality because he is the state, municipality will come under him.
My lord, what I am
Yes.
suggesting, my lord, subject to your lordship's correction, if that writ petition comes up and tagged together, the petitioner against whom he is having the grievances will remain. My lord, lordship may decide by hearing both of them, and whatever will be held by your lordship, my lord, we can act accordingly, my lord. Because pendency of that writ petition will also be an embargo on us.
Be decided once the report is filed by you as well as.
My lord, our report, we are ready with the report, my lord. I may file it right now. But that will, whatever I have explained, my lord, that will be the situation because the other person's name of that writ petitioner has been forwarded by the municipality and we have approved. Now, my lord, that has to go. Municipality has to come up and speak that yes, we have given a wrong gradation list. By mistaken or whatever it is. We have sought for a.
Have you made him a party, the other person?
No, he is not a party in this writ petition.
In my writ petition, my lord, he is not going to do anything.
Take down. The petitioner has preferred the present
Because
writ
page
petition.
60, your lordship, one page where
Seeking-
board of direct.
Just a minute. Seeking direction against the respondents for payment of his salary as tax collector from the date of his joining till date. It is the case of the petitioner that he was appointed as a casual employee of the respondent municipality on.
My lord, initially I was appointed on, my lord, 29/9/1997.
29/9/1997.
But it was approved on 2000.
By
3rd of April 2000.
Got permanent on 3rd April 2000.
later the same was made permanent
On 3rd
by
April
order dated 3rd April
2000.
2000. When were you promoted?
My lord,
When were you promoted?
my lord, I was promoted on 38th January
On
2024
30th 1/2024.
and I joined on 7th February 2024.
Petitioner was promoted to the post of tax collector.
My lord, tax collector.
Tax collector. It is a submission that he has been performing the duty of the tax collector, but has not been paid salary in the same grade. Full stop. Despite representation, no action has been taken by the respondents. Full stop. Despite several representation, no action has been taken by the respondents. Learned counsel for the respondent state appears and states that another writ petition number
My lord,
Number-
WPA 21636 of 2024.
21636
636
of
2024.
2024
Shopon Kumar Sarkar versus State of West Bengal.
pending before this court, which is connected to the present writ petition, since the petitioner in the said writ petition is also claiming his salary to the post of tax collector.
And my lord, one more thing, that no formal proposal for promotion has been sent by the municipality to us, to the
Is
state.
claiming his salary to the post of tax collector, though an order has been issued by the respondent corporation wherein he has been downgraded to the post of clerk.
My lord, may I take the in division bench matter, my lord?
Your matter, sir.
Yes, my lord. My junior is there. Great. Grateful.
He has been downgraded to the post of clerk, which is under challenge in that writ petition. In writ petition number so and so. Full stop. let both the writ petitions be listed together on next Wednesday.
Lord, one more line only, that no formal proposal for promotion has ever been sent by the municipality to us.
Learned
So we
counsel.
cannot act.
We will see that.
Well, that's what
Let
my
him
submission was.
come.
The municipality should send a formal proposal. They are keeping it within their own pocket, that won't.
Can you please contact the municipality also so that they are,
I'll try.
My lord,
please,
may I be allowed to file the supplementary
no
affidavit
need, madam.
with the
We'll-
typed copy, my lord?
We'll see that. If we need it, we'll take it.
I'm grateful.
Grateful. Lordship, in item number 14, I'm led by Mr. Srijit Chakraborty. Lordship, there was a direction upon us to file our reply. We are filing the same. We have also served the copy upon the added respondents.
Madam, for the state respondent.
Yes,
Reply to the affidavit in opposition.
Lordship. This is affidavit or in reply, Lordship. Lordship, my only humble prayer is kindly takes up this matter on Friday, Lordship, because
Take it up now.
Lordship, Mr. Srijit Chakraborty is going to argue in this matter. He's currently engaged in another matter, hearing matter, Lordship. This is my only humble request. If your Lordship kindly makes the matter not today,
Your Lordship,
or kindly takes it up at 2 p.m. Lordship.
Can't be 2 p.m.
Lordship, then kindly take it
copy is
up.
not served upon me, Your Lordship.
Give a
I have given the served upon the copy upon the added respondent, Lordship. Respondent number 9, I shall serve her within the course of the day, Lordship.
give
Because we have received the opposition from added respondent. That's why we have only given them.
give a copy. Give a copy.
Lordship, I shall serve the same within the course of the same. I'm only praying for not today, Lordship, in that case.
A reply to the affidavit in opposition is taken on record.
Lordship needs some time to produce the same.
List on
Friday, rakho na.
My lord, kindly keep it not today, my lord. Because my senior, Mr. Himadishika Chakraborty, is leading me in this matter.
you are
And
appearing for
while I'm appearing for the state respondent, my lord.
state
Mr.
response. Who's for the
Chakraborty is appearing.
municipality?
For the corporation.
You are for the corporation. We'll have it Wednesday.
Lordship, returnable, your Lordship.
Next
Lordship.
Wednesday.
Next Tuesday. Wednesday.
Grateful, your Lordship.
Grateful, my lord. Yeah.
Yes.
My lord, in this matter, I am for the petitioner. My lord, as per the earlier order of the honorable court, my lord, I have already complied the order and amend the cost title of the instant writ petition. But coming back to the instant writ petition, the fact
That
for
is
the
G+4 building with 3 extra floors without any sanction plan.
yes, my lord. Through the RTA report, we came to know, my lord.
3 extra floors.
My lord, I am for the private respondent number 8 to 17, my lord. We are the landowner, my lord. We have given the land for construction of the same to the respondent number 18, my lord, who is the developer in respect of the said property, my lord.
Very good.
Developed, my lord, without the sanction plan, my lord. And if as per the communication of the Howrah Municipal Corporation, my lord, if there is any kind of my lord, extra floor, my lord, beyond the sanction
Already
plan,
we
my
have
lord, let the
Already we have completed our process under section 177, my lord. Already we have given hearing. Already we have passed the self demolition order. Now only requirement is that if they do not self demolish the building, we will demolish it. If your
What
lordship-
more you want?
Nothing served upon us, my lord.
Give a copy, Mr.
Nothing served
Yeah,
upon
my
us.
lord, keep
Lord,
it,
according
any
to
day,
the
my lord, I will come with the service.
When you
according to the
If your
instructions.
lordship so desires.
We'll just make it not today, then you give the copy, we'll dispose it off. What is that?
Tomorrow is the original site day. So
Friday?
If
Friday.
today, within due course of law, time,
এটা কি সম্ভব?
My lord, only humble submission before your lordship, my lord, according to the instruction of my client, my lord, the spot inspection has not been conducted. Directly, the notice of hearing has been given.
You challenge the order, whatever you have to do. We are not concerned. This is not your petition.
But we will, my lord may pass an order regarding that I will serve a self demolition notice in the meantime.
And in default of the self-demolition notice, the corporation will demolish the same.
Automatically, that is the law. Then my lord, pass the final order. You can lordship and pass the as your lordship desires.
You don't give the copy, I'll pass the final order.
My lord.
Learned counsel for the, this is for the first time or no?
First time, my lord, first time.
This is the first time.
First time, my lord.
So can it be posted on Tuesday, man?
Tuesday, we'll have it on Tuesday. Then I'll make it not today, we'll have it on Tuesday.
Wednesday.
Wednesday, we'll have it Wednesday.
Wednesday.
Not today, Wednesday.
Wednesday.
Grateful, my lord.
Wednesday.
Come with the order, we'll dispose it off.
My lord, my lord.
My lord, I am led by Mrs. Kumkum Mukherjee in this matter. I am for the petitioner and I am seeking for 1 week more accommodation to file the report for affidavit of opposition.
My lord, I am filing my opposition. I have served them. For the respondent number 5.
Give a copy.
I'm responding of the petitioner. I've already served the petitioner.
Give it to the corporation
filed
also.
our affidavit to the main writ petition.
Yeah, filed it.
Till date, we have not received any reply to them.
That's what she's seeking time.
Very good. Sir,
Learned counsel for the petitioner seeks further time of, seeks and is granted further time of 1 week to file her exception, reply to the affidavit in opposition.
affidavit of opposition.
When is the interim order expiring?
July. No. 8 weeks. From May, July and as per my lord last order on 23rd May, it was extended for 8 weeks or until further orders.
8 weeks will be 2 months. 6.
End of July.
Affidavit in opposition filed by respondent number 5 is taken on record. Counsel for the petitioner seeks and is granted
1 more week.
1 week to file her reply to the same. List after. We can have it after 2 weeks, Mr. Mukherjee.
My lord.
List after 2 weeks. 16th July. Or we'll finish it on 16th of July then. Madam, please
Yes,
be prepared. We'll finish it off.
my lord.
My lord.
Oblige, my lord.
Rest of the matters we can have after lunch. So Ghosh, you're here, you're not going anywhere.
My lord,
You're here only after lunch also.
yesterday also after the lunch my matter was taken up. Today also.
So,
The next matter is of mine.
Are you here after lunch or not?
My lord.
You're here till 4:30. I always see you here.
My lord, this is my writ of habeas corpus, my lord.
But I am for the KMC. দিতে হবে।
So you had this listed today?
Yes, it was listed. It was before my lord Justice Tapobrata Chakraborty and Honorable Justice my lord Ritobrata Mitra, my lord.
Yes, what happened?
My lord, the matter was again, my lord, placed on 16th July, my lord.
16th July.
16th July. And
For what?
this was the for my lord for my lord further consideration, my lord.
Any order passed?
My lord, the order earlier passed is this, my lord. I have been this is the order, my lord. I was given liberty to go through the police report. In the police report, it was found that he was residing within the jurisdiction of Domdom police station and given an address, but she was not been found in the address given therein. And this is the my lord application.
Nothing is given.
And the complaint of missing was lodged on 16th May.
The mother-in-law and the wife.
I have not finished my submission.
Just a minute, sir. Just a minute. You'll get your chance.
The mother-in-law of Mr. Tapan Rai, who is present in court, has lodged the complaint. Not mother-in-law, my lord, Mr. Tapan Rai, the wife of Mr. Tapan Rai lodged the complaint on 16 May. That is being annexed in the page 60.
We are not concerned. Now you tell me one thing. You have filed a writ petition earlier.
Yes.
WPA 7581 of 2025.
Yes.
You are seeking identical relief in the present
My lord,
petition.
This is, my lord, actually the promoter who has been engaged. The development agreement has not been registered, and that development agreement
We
remain.
are not concerned with your civil dispute.
Yes, my lord, because at the instance of the promoter, my lord, the record of the plot of land was.
We are not concerned with that also, sir.
That was the contention.
We are not concerned with that. We are only concerned your prayer clause in both the writ petitions are identical.
My lord,
how have you filed two writ petitions on the same prayer clause?
my lord, first of all, my lord, today, my lord, the business has been fixed today for hearing of the first writ petition, my lord, and the second writ petition.
Sir, can you wait?
My lord, this is the first writ petition pertaining to the correction of records of the municipal records. And second,
it is not correction of municipal records, sir. This is, read it.
My lord, that is the writ petition number.
Yes.
7581.
Read the prayer clause.
Yes, clause A. Issue a writ of or in nature of mandamus commanding the respondent number 7029 each of them to act in accordance with law and to assign reason as to why the respondent number 11 and 12 should not be restrained to interfere in the premises number such and such within the borough number 1 of the respondent number 3, that is Kolkata Municipal Corporation. Respondent number 11 and 12 is the promoter who has executed an unregistered agreement, and the said unregistered agreement is become void following the provision of the Registration Act. Now, my lord, the mandamus commanding respondent number such and such is of the
You can file anything you want to before any court. Anything which comes to your mind, you will file it. What kind of petitions are this? Now, where's the petitioner?
Petitioner is, my lord, I have said that Purnima Bishwas is missing since 16th May, my lord.
The report says she is residing at her home and she has met the officer concerned.
Yes, but I
So-
have,
I will go by what the order says. All right. So stop saying that she is missing.
my lord, she is missing.
She has already met the officer concerned.
Yes,
Take down.
my lord.
Yes,
the-
what do you have to say?
Yes, my lord.
My lord, let this, before deciding, my lord, this, if this instant writ petition is being deciding on this, my lord, this will not serve the purpose of justice, my lord. Why, my lord? This, again, I have filed one CAN application in the writ of habeas corpus, disclosing the further, my lord, the development in the said incidents.
Pursue your remedies in the
Yes.
habeas corpus. All right.
Yes, and
I
my lord,
will ask
my
you
lord,
to produce Purnima Biswas should be here. Anyway, now you
and my lord, your
are not concerned with your CAN application, sir.
very good, my lord. I am praying adjournment to this 7-8.
Your praying adjournment will not help you.
My lord, this is not
All
on the
right.
board, my lord. This is on the prayer of.
I have asked for it. I have got the file. All right. Your adjournment doesn't matter to me. Yes, you tell.
There are complaints, police complaints, why Purnia, the petitioner hearing that she has been intimidated, her son has been tortured.
Who are you?
Yes, madam.
Who are you?
I am for some of the private.
Who privates? What do you mean some of the privates on it?
The co-sharers of the property.
Co-sharers of the property.
Yes.
So your private respondent number what?
Number 11 and 12.
11 and 12. All right.
No, Shankar Sobidas.
Yes, tell me now.
Now, my lord, I have got a photocopy of the.
My lord, this is 11.
Hold it.
My lord,
You will
11.
not speak when the other person is speaking. Don't you know how to address the court? Yes.
Yes, my lord,
11 number 12 and
what
11.
I
This
am
one number
allowed
11,
to
12.
say,
Mister, I'm warning you. I'm warning you.
my lord, Purnima Bishwas herself has complained that her son-in-law has tortured, physically tortured her son and her daughter, married daughter, that means the wife of the son-in-law. And she also says that she has engaged the promoter of her own will. No, there was no coercion on her part to engage the promoter. So this is, she said, in a complaint. And no action was taken. I don't know what action has taken. This is written in Bengali.
All right. Take down. The petitioner. The petitioner had filed WPA number 7581 of 2025 as well as WPA
My lord, I am to be given chance for reply, my lord.
13506 of 2025. Yes, tell me, what do you want to say?
My lord, in the 13506, this is the first writ petition. My lord, there is a specific.
I am only asking for the petitioner to be here on the next date. Take down. Writ petition number 7581 of 2025 as well as writ petition 13506 of 2025. Full stop. The petitioner had written a letter to the Honorable Chief Justice, Calcutta High Court, dated 22/5/2025, which has been marked and tagged along with the present writ petition by the directions of the Honorable Chief Justice. Full stop. The letter contains that the petitioner is an aged widow and a senior citizen, aged about 65 years. Full stop. She further contains, the letter further contains that she is the co-owner of premises number 4/H/7 Roy Para Lane, PS Sinthi, Kolkata. Full stop. She had entered into she along with the co-owners had entered into a development agreement with Muhammad Salim and Shankar Das for development of the said premises. Full stop. She further states in the letter that her estranged son-in-law, Tapan Roy, @Tapan Ray Paul, resident of 33/61/2, presently at 5/1C Hameday Lane, Calcutta, who is a lawyer having his chamber at room number 20E, of 10, Old Post Office, Calcutta, without any authority of law and without her consent, had forcibly filed a number of litigation in her name and on her behalf against the developer and other tenants with an ulterior motive. She further states that the said atrocious son-in-law she further states that her son-in-law severely assaulted her with fist and blows and kicks and had compelled her to sign and file a number of cases, including the present writ petition WPA number 7581 of 2025. Full stop. She further states that she has no intention to file any such case, and the said said son-in-law, who is also a lawyer by profession, has compelled her to do so at his own dictates and intimidations. She has requested for withdrawal or dismissal of the writ petition for non-prosecution. This court deems it appropriate to cause the appearance of Shri Purnima Biswas to ascertain the true facts. Let Miss Biswas appear. Learned counsel for the petitioner states that he will make sure that Miss Biswas will appear before this court on Monday. On Monday.
My lord, instead of Monday, can it be on Tuesday, my lord?
Tuesday.
Tuesday.
Let the second copy of the writ petition be given, my lord, because I have made a request to the petitioner.
Give a copy.
83. I have already. It has already been served.
But this has not been served as per the office report.
Yes, affidavit of service with the record, my lord.
Sir, give a copy.
Yes, I'll tell my.
I'm good.
He will ensure that
I appear for the respondent.
My lord, I am for the petitioner, my lord. My lord, in this matter, Mr. Bikashanjan Bhattacharya is leading us, my lord. And due to some personal problem, he couldn't reach the court, my lord. Just praying for not today, my lord.
What are you seeking? Drainage?
Drainage. Will you submit a report to your losses court, my lord?
Yes, yes.
We require certain documents which they could not, my lord. Let them say what they want to say. Then your lordship takes it up not my lord, not this my lord, week then, because tomorrow is the original side day, only Friday. Your lordship my lord, post it Monday or Tuesday, any day.
Tuesday.
Oblige, my lord.
Sir, I am for the state respondent. I beg
You
to appear for
appear
the
for
final
the
decision.
petitioner.
Yes.
Lordship, this matter, Lordship, on the last 2 days, your Lordship, the private respondent has sought for time, your Lordship. Last 2 occasions. Lordship, this is the matter when on the last date I have placed reliance at page 66.
Yes.
Page 66. This is issued by the Bidhannagar Municipal Corporation, wherein there is a direction that notice for repairing and renovation of existing 3-storied building structure at BD 91, Salt Lake, Kolkata 64. In response to a specific complaint.
You appear for Bidhannagar.
In response to a specific complaint, an inspection was conducted at your premises at BD such and such by the engineers of the corporation. And it is found that the overall condition of the existing 3-storied building structure, especially second floor balcony portion, is very poor and needs immediate repairing. Therefore, you are hereby asked to take the appropriate remedial measures by repairing and renovation of existing 3-storied building structure, including second floor balcony portion, such and such, under supervision of a qualified and experienced structural engineer immediately in order to avoid any untoward incident to ensure the safety of the residents of the building. A compliance report in this regard is to be submitted within 6 weeks from the date of issuance of this notice. So this was what was the notice, your Lordship, which is dated 24th of April 2024. This petition was filed in the month of September 2024. Lordship, what is happening, your Lordship, at this first floor and the second, at the ground floor and the portion of the first floor, Lordship, the entire ground floor and first floor, I'm running a management college. Lordship, now the structure, there are cracks which have developed at the third floor and also on the portions of the second floor. And now because the chunks were falling on the staffs of the college and the students, your Lordship. 2 of the staffs were wounded, your Lordship. At that relevant point of time, we have approached since there are the 2 options, either the landlord should carry on the renovation or repairing work pursuant to the agreement, which I have also pleaded, or either the municipality should issue necessary notice because it endangers the lives of the citizens. So in that pretext, in the municipality has already issued this order for renovation. Lordship also relying on the particular section which is West Bengal Municipal Act 1993, section 222.
Wait.
Lordship.
Yes. Which
Look.
section?
Section 222. May I place the section? The Board of Councillors may, for sufficient reason, by an order, require the owner or the occupier of any building abutting on a public or private street to keep the external parts of the building, including the roof thereof, in proper repair,
with lime plaster or other material or properly painted to the satisfaction of the Board of Councillor. Now, what is applicable in my case? Clause 2. If such owner or occupier makes persistent default in carrying an order made in this behalf, the Board of Councillor may itself carry out the work and recover the cost thereof from the owner or the occupier of the building, as the case may be. I'll be placing the applicability of clause 2 of section 222. Further, notwithstanding anything contained in any other law for the timing in force, the Board of Councillor may apportion the cost incurred under subsection such and such between the owner and the occupier in such manner as it may consider just and reasonable. I will be praying, Your Lordship, that necessary directions be passed when the municipality has already inspected the premises and it has come to the conclusion that this building needs immediate repair work. In terms of section 222, subsection 2.
Yes, what else?
Lordship, that is my case. Only with regard to the applicability of that section, let the municipality be directed either to carry on the necessary construction, repairing work, or the owner, which is the respondent number 4, may be directed to carry on the same. Only implementation of the same. Because once it is not implemented, it is also incumbent upon the municipality to, the compliance report was to be submitted. Now, the difficulty is that the municipal corporation is also sitting. They are aware that this compliance report has to be submitted within 6 weeks. There is no further compliance, Your Lordship. That is, I'm
a licensing.
Lordship.
When did your license expire?
Lordship, this leave and license agreement is of 1st June 2016. And pursuant to clause 13, Lordship, this agreement.
30th May 2021.
1st June 2016, and pursuant to order passed by the Honorable Court, such temporary injunction order was made absolute by an order dated 27. That is annexure P8. Page 69.
Yes.
Page 69 is the order.
Yes.
The order starts, the order dated 27th April 2023. And the next page, page 70,
Yes.
that the order dated 18/2/2022 is hereby made absolute to disposal of the suit. So I'm in occupation.
You're in
and
occupation.
Lordship, I'm in occupation.
You're
I'm in lawful occupation, Your Lordship. And by the pursuant to this order, Your Lordship, now it has been stated that the injunction order was made absolute. And the leave and license agreement, which is the first annexure P1. This clause or the agreement also contains the clause wherein the landlord is to carry on the necessary repairing work. That clause is also there. That is clause 13. I will not press that clause because I am seeking my necessary relief before this Honorable Court upon directions upon the municipal corporation. Page 34, clause 13.
So in your suit, ask for this.
Lordship?
In your suit, ask for the repair.
Lordship, it is, I could have. Lordship, in the suit, I can ask for a repair upon the landlord. But since it is the responsibility of the municipality under section 222 to carry on the necessary steps to intimate, because we are paying the property tax in respect of the premises. So it is for the municipality to also, it is not issued by any other authorities, it is by the statutory body. So this, Your Lordship, implementation of this order, I cannot go before the suit court. My only relief is before this Honorable Court. Lordship may kindly consider.
Speak in the mic. Yes.
We are guided by the.
It's not on.
Yes, I'm sorry, Miller.
Yes.
We are guided by the Act of 2006, the West Bengal Municipal Corporation Act. Now, Millard, before starting with the Millard case, my learned friend has referred to page 66. That is the show cause notice. It is Millard issued under section Millard 268 of the Act of 2006. Now, your lordship will kindly take 268.
Yes. Where's the 2006 Act?
দিয়ে দিন দিয়ে দিন বইটা দিয়ে দিন যদি লাগে তো দিয়ে দিন
The power to
Yes.
268, power to order demolition of building dangerous, ruinous, or unfit for human habitation, Millard. So, Millard, this case, Commissioner has the power to order for demolition, Millard. That is the reason, Millard, this notice at page 66 of the writ
So
petition.
declare it
Millard,
dangerous
kindly
and
direct-
demolish it.
Millard, kindly direct them to evacuate, Millard. We will direct. We will demolish.
First pass an order, sir. You have only done the
Millard,
pass an order of demolition.
We shall, Millard, upon giving notice of hearing to all the
Pass an
parties,
order of
Millard,
demolition.
we shall. Kindly direct us.
Millard, I beg to
Don't
appear.
even direct.
I'm
It's an entire building, your lordship.
Let it be demolished, madam. It has become
Lordship,
dangerous.
it
and
is only
dilapidated.
requires repair work.
No repair work, no.
Millard, we are not
It's
guided by the
dangerous,
Act of
leave it. You are just a
1993.
tenant.
So, Millard, these provisions of section 222 is not applicable in our case. The prayer that has been sought for is a direction upon us to repair, which is a private building. Since we are guided by the Act of 2006, we have invoked the provisions, Millard, under 268.
All
We have the power to demolish, not to, Millard, make any repair work.
Yes.
Millard, I beg to appear for the private respondent. I'm the landowner, Millard. 2 civil suits are pending.
Yes.
One at our behest. The expiry of the legal license agreement was on 31st May 2021. Your lordship will get that at page 49. We filed an eviction suit. Lordship kindly comes to page 49.
13/6 or 31st?
31st of May 2021.
Page?
Page 49. Lordship kindly comes to the third paragraph, Lordship. Third paragraph of page 49.
Yes.
Yes, my lord. Please be informed that the said agreement for leave and license dated 1st of June 2016 and supplementary leave and license agreement to the leave and license agreement dated 1st of June 2016 is continued till 31st of May 2021 and required to be extended for further period of 5 years upon enhanced rate of license fee as per the terms of the agreement dated 1st of June 2016. Now, my lords, after that, we had sent a notice to quit. We have filed a eviction suit in Barashat. Thereafter, they are not paying us any license fee as of now. And my lords, they have suppressed that they have done a criminal case against us, alleging that we are trespassing over our own property. My lord, they have not stated that. I have the certified copy, my lord. So, my lord, whatever directions your lordship passes kindly takes into consideration. The civil suits are pending. They have adequate remedy over there. They have lodged a criminal case. They have suppressed that. I have the certified copy.
What criminal case?
They have lodged a criminal case, that is MP case number
For what?
110 of 2022 at Bidhan Nagar.
For what, sir?
The sections are of criminal trespass, extortion, and another sections, my lord. Against the petition number 2 has lodged against me, Kamala Kormakar, who I'm the owner. But I'll give the certified copy if required. Look, this is under sections 384, 441, 425, 506, 188. And in the complaint, they have stated that we are trying to violate the injunction order. So, my lord, they are trying to avail all the remedies under the sun.
Yes, madam.
Lordship, now what my learned friend for the municipal corporation has stated, that they do not have provisions for repair even under the West Bengal Municipal Corporation Act 2006. Well, section 96A clearly provides precaution in case of dangerous structure, whereas also direction can be issued by the municipal corporation themselves. then like they are not remediless, then only demolition order we can pass. If any structure is deemed by the corporation to be in ruinous state and dangerous to the passers-by or the occupiers or neighbor structures, the corporation may by notice require the owner or the occupier to fence off, take down, secure or repair such structure. So this notice was not issued under the other section. This notice was issued under section 96A. That's one part.
Where is when you act in hand in glove, this is what happens. Yes.
Lordship. Now with coming to the contentions made by the
Yes.
private respondent,
Yes.
the landlord.
Yes.
It is the duty of the landlord. It is pursuant to an agreement. I have opened a college. It is not that I am a tenant, 11 months agreement. Tomorrow you ask me to go out, because there are students who have already taken admission affiliated to a university. It's annexed college. So there's a college which is running. Now they have the lease term when it was about the leave and license agreement. Before it could expire, we had already approached the suit court seeking the remedy wherein injunction was given. It was considered that they are collecting a rent of rupees 72,000 per month, which has increased with time, and till date they are collecting the same. Now, despite collecting such a huge rent, I was not allowed to enter into the premises. In that pretext, when the matter was heard by the learned suit court, the interim order was made absolute. Now the suit remains. I am not aggrieved, or my learned friend is not aggrieved by pendency of the suit, as has just been placed before this honorable court, that we are invoking all possible courts. So wherever my remedy lies, I'll have to go there. Now, Lordship,
Why?
what was happening, Your Lordship? They were forcefully restraining us.
Yes.
A criminal matter was filed.
No, they have not.
May I humbly submit before Your Lordship, this is a case wherein I am praying for an action of the corporation. If there are 10 suits, whether not referring to the criminal case amounts to suppression, my lord, can the learned counsel make any kind of allegations, any allegation, just because he has to defend, Your Lordship, the submission made before this honorable court is that a criminal case is filed, that is not referred in the writ petition. Is it a subject matter of the writ petition?
Madam, the section which you have relied upon, that is subject to the building being declared dangerous.
Lordship, 96A.
That is only after the building is declared to be dangerous. Today,
Lordship,
a notice has been issued.
Lordship,
Nothing more has been done.
Lordship.
So the building is still not dangerous. Let it be
Lordship.
declared dangerous and let them take action. Let them demolish the building.
Lordship, it is not dangerous, Your Lordship. A building, it requires repair work.
Oh, they have issued a notice. They should proceed ahead and pass an order of demolition. Mr. Nag, you are very proactive. Very proactive. I'm amazed to see the way you are functioning. How many buildings you have inspected in this area, in your area, where you have issued this kind of a notice? Can you file an affidavit to that effect? Huh?
Lord, I will take it up with my officer. This should not have.
You are being extremely proactive, Mr. Nag. It's so good to see the corporation working in such high spirits.
Lord, the difficulty is we are burdened with so much of.
Mr. Nag,
I am not giving.
you think this notice comes,
I am not giving it.
this comes from where we all know
I am not giving it. Not at all giving it.
and how it comes.
Not giving
Take action, demolish the building.
it. Lord, we shall.
The petitioner, comma.
268.
The petition. एक ही है। हाँ। The petitioners. The petitioners, by way of the present writ petition, comma, is aggrieved by the inaction on the part of the respondent municipality in failing to take appropriate steps to ensure that respondent number 4 carries out necessary repair and renovation work in respect of the building situated at BD 91, Sector 1, Salt Lake City, Calcutta. Full stop. The petitioner submits that the respondent number 4 is the owner of the said premises, and the petitioner has been in possession thereof as a lessee under a
Leave and
leave and license
Licensing.
agreement dated 1/6/2016. Full stop.
Page 29.
Although the said license agreement expired on 31st of May 2021, the petitioner did not vacate the premises. Full stop. Consequently, respondent number 4 initiated eviction proceedings against the petitioner, which are presently pending before,
Court of Learned District and
which are pending adjudication before the Learned Civil Court, Barasat, in title suit number
Title suit number 1201.
1201 of 2022. Full stop. The petitioner further contends that the building in question is in dilapidated condition and in urgent need of repair and renovation. Full stop. Counsel for the petitioner says that she had lodged a complaint before the respondent municipality, who in turn conducted an inspection of the premises and subsequently issued show cause notice dated 24/4/2024, directing the respondent number 4 to undertake the necessary renovation. Full stop. However, despite such direction, respondent number 4 has not taken any steps to carry out the requisite work. Full stop.
Title suit was pending there.
Learned counsel for the petitioner further
Slight
contend.
indulgence, my lord.
What?
My title suit was pending, my lord. My submission is that is why I could not.
I will recall.
Much of it.
Learned counsel for the petitioner further relied upon the West Bengal Municipal Corporation Act, section 266, right? 222 to contend her to agitate her contention that if the building is in dilapidated, if the building is that if the Board of Councillors, for sufficient reasons, by an order require the owner of the occupier or the occupier of any building to keep the external part of the building, including the roof,
222. 8 West Bengal Municipal Act.
in proper repair
Municipal Corporation Act.
with lime, plaster and other materials to the satisfaction of the Board of Councillors. She relies on clause 2 of 222, which says that if the owner or occupier default in carrying out the order on behalf of the Board of Councillors, then in that case, the Board of Councillors will carry out the said repair work and recover the cost from the owner. Full stop. She shall carry out the repair work and recover the cost from the owner. Full stop. Owner word is only the owner or occupier, madam? Owner. Owner or occupier.
Owner or
Owner or-
section says owner or occupier.
Owner or occupier. Full stop. She further relies on section 96A of the West Bengal Municipal Corporation Act 2006, 1993, Municipal Act. 96A, which deals with precautions in case of dangerous structures. Full stop. Any other submission you have?
Your Lordship. I'm praying for repairing work, not for demolition.
All right.
I'm
Learned-
running a college, Your Lordship,
Yes.
management college.
Yes, learned counsel for the respondent corporation states that the notice dated 24/4/2024 has been issued under section 268 of the West Bengal Municipal Corporation Act 2006. Mr. Nag, counsel for the corporation, further contends that the West Bengal Municipal Corporation Act 1993 does not govern them any longer. Full stop. They are, comma. He contends that the applicable provision is of the West Bengal Municipal Corporation Act 2006. Full stop. Mr. Nag further contends that Section 96A will come into effect only once an order is passed under section, which is the dilapidated condition.
268 is the,
26. Only once the building has been declared as dilapidated after following the due process under section 268 of the West Bengal Municipal Corporation Act.
and
Full stop.
Millard,
Thus, he contends that section 96A is not applicable as far as the petitioner is concerned. Yes.
and Millard, even if section 96A has to be contemplated, there has to be a hearing given or an opportunity for repairing. That is
But
there.
that is a secondary stage. First, you have to declare the building to be dilapidated.
Millard.
Full stop. After following the due process of law under the Act and the rules. 268 of the Municipal Corporation Act. And relevant rules. Full stop. Learned counsel for the respondent.
Number 4.
Number
Right.
4. Yes. What is your contention? Learned counsel for
My
the respondent
contention,
number
Lord-
4 states that the petitioner shall be governed by the lease and license agreement, wherein clause 13 specifies a provision wherein the petitioner is at liberty to get the building repaired, where the petitioner can, which is clause 13 is page
Lordship, clause 13.
Their
13.
contention- my contention is that leave license agreement has already expired on 2020.
All right. The petitioner states that there's a clause, there's an inbuilt clause in the lease and license agreement, wherein the petitioner can,
Clause 13 is
See-
at page 34, which is not.
for
the
repair of the building, full stop. Though the respondent, the private respondent states that the said lease and license agreement has ended with efflux of time on 31/5/2021. Full stop. Any other argument? He further contends that civil suits are pending between the parties,
And my lord, the criminal case.
as well as there are criminal proceedings also initiated by the petitioner against
2.
the respondent.
Petition number 2.
Petitioner number?
Petition number 2 has lodged a criminal case against.
Yes, petitioner. Petitioner number 2 has initiated a criminal complaint against respondent.
Number 4.
Number 4. Full stop. In this
Lordship,
court has heard the, yes, madam.
Lordship, and by the, in this.
You
civil
have
suit-
already, I have recorded all your submissions.
Lordship, only with regard to the civil suit, Lordship, order dated 27th April 2023, the interim order has been made absolute.
ऊपर जहाँ petitioner submission है ना, वहाँ एक और line ले लेना. Petitioner contends that the petitioner, that in the civil suit, the the petitioner has got an ex parte in, what is it?
Lordship, not ex parte, Your Lordship. It was heard in the presence of
That is for a civil
for
civil
both
dispute,
sides.
madam. This has got nothing to do with your repair.
Lordship, only with regard to since this suit, Your Lordship,
Yes.
where it has expired, what has just been stated, Your Lordship.
Yes.
In title suit number 55 of 2022 by order dated 27th April 2023, page 69. Your Lordship, I'm still in continuation of the agreement. The court has protected me with this order.
Learned counsel for the वहीं ऊपर डाल देना. Contents that
Page 69.
by
In this.
contents that a civil suit is pending before the civil suit number 55 of 22 is pending before the, which court is this?
It's Civil Judge Junior Division.
Junior Division, Bidhan. Full stop.
And by this, pursuant to this suit, my agreement is extended.
That's all right, madam. I'm not concerned with your.
Pursuant to the suit, the agreement
Take That's why एक line add करते हैं. Yes. Is pending. All right. This court has heard the submission advanced by the learned counsel for the parties and has perused the materials on record. From the perusal of the record, it is evident that the petitioner's grievance primarily arises from the alleged failure of respondent number 4 to undertake repair and renovation of the premises, despite a direction being issued by the respondent corporation, municipality, full stop. However, it is also undisputed that the petitioner's right to occupy the said premises itself is in serious dispute, inasmuch as the leave and license agreement has already expired on 31st of May 2021, full stop. The eviction proceeding initiated by respondent number 1, being titled suit, respondent number 4, being titled suit number 1201 of 2022 is pending before the Civil Judge Senior Division, Barasat, full stop. Therefore, the core issue pertaining to possession, legal entitlement, and the locus of the petitioner in respect of the said premises is already sub judice before a competent civil court, full stop. Also, the reliance of the petitioner on the alleged notice dated 24/4/2024 asking the petitioner, asking the respondent number 4 to carry out the repair work is also under section 268 of the so-and-so Act, the West Bengal Municipal Corporation Act, as stated by the counsel for the respondent, as stated by the respondent corporation, full stop. If the respondent feels that the said building is dangerous, then appropriate proceedings should be conducted in terms of the notice given to the petitioner, to the respondent, respondent number 4, and the corporation is directed to decide the state of the building after following the due process of law within a period of 4 weeks, 6 weeks, how much time?
4 weeks.
Within a period of 4 weeks, full stop. In case the petitioner finds that the said building is dangerous and dilapidated, necessary actions shall be taken by the corporation in terms of the statute and the applicable rules, full stop. In view of the above, this court is of the considered opinion that the petitioner who has conspicuously chosen to remain in occupation of the premises without any subsisting or enforceable legal right post expiry of the license agreement cannot be permitted to invoke the equitable and discretionary writ jurisdiction of this court
Lordship
under
kindly hears, I am protected by an order of the civil
Constitution
court.
of India.
Lordship, I am
The
protected by an
petitioner-
order of the civil court. That
Madam,
order is permitted.
Challenge this order, madam.
Lordship, I am protected by the order of the civil court.
Challenge this order. With the above direction, the present writ petition is dismissed.
I'm so
Grateful, man.
Of the Constitution.
Lord, I am
Yes,
seeking an indulgence, my lord, which is not true with regard to this matter.
yes.
My lord, what has happened, my lord? My lord, there is a
एक line और लिखवा दो इसमें. The petitioner, such a plea in substance is aimed at enforcing an individual or private right, which is already the subject matter of private dispute. In view of the such disputed question of fact, this court is not inclined to interfere in the present writ petition under Article 226 of the Constitution. Yes,
Milord, when Milord was sitting in the circuit bench, Milord,
yes,
at that point of time, Milord, Justice Kaushik Chanda was having the urgent determination, Milord.
yes.
In there, Milord, we had moved a matter where we had another writ petition was moved, Milord, where an interim order was.
Why are you mentioning now?
Why, Milord? I'm saying so, Milord. We had mentioned it for the urgency before my Lord the Chief Justice, and
Yes.
my Lord the Chief Justice has been pleased to assign a modification application, Milord, which is generally to be taken up by my Lord Justice Chief Kaushik Chanda, Milord, who is right now in Port Blair, Milord, at 2:30 p.m., Milord, with the liberty that we mentioned it before, Milord, for taking it up. That is the reason, Milord, I am taking this indulgence.
So
and
who, Mr. Chando is going to, Justice Chando will,
Justice Chando's modification application, as Justice Chando is in Port Blair, my lord.
yes.
My lord, the Chief Justice has considered the urgency and has assigned the matter before my lord. With a liberty that we mention it, my lord, for an urgent hearing, my lord, because there was an interim order, my lord. And
That's right, but who has assigned at 2:30?
my lord, the Honorable the Chief Justice, my lord.
Before this court at
Before this
2:30?
court.
I will not hear it.
My lord,
I will not hear it at 2:30.
my lord, if it can be, I am not asking for today, my lord. If
Give me the assignment where the Chief Justice has assigned the matter at 2:30 in my court. Where has the Chief Justice said that this matter should be listed at 2:30 before?
no, my lord, it has not been. My lord will not take me amiss, my lord. My lord, it has not been 2:30.
Nobody can assign a
No.
matter at 2:30 in
But
this
only
court.
the liberty to mention it before my lords. It is my lord to
Ah,
decide.
You
My lord, at
just,
2:30 it has been assigned at 2:30.
2:30 it has been assigned
Yes,
to
yes,
this
my lord.
court. Let it come, we'll see.
My lord, the difficulty is, my lord, it will be demolished, my lord, if it is not taken up tomorrow.
We'll see it, Mr. Give the slip.
My lord, my lord.
Nobody assigns a matter.
No, my lord, absolutely. My lord, perhaps I could not communicate, my lord. It was only that at 2:30 the assignment order was signed.
Very
That is what we were trying to say.
enforcing an individual or private right which is already under dispute, which is already a subject matter of civil dispute.
On 99 for the petitioner in this matter.
I am for the respondent.
Yes.
Private respondent.
No, the matter relates to an unauthorized construction. When this matter was initially moved, my lord Justice, my lord Kaushik Chandra has been pleased to pass an order, directed the municipality to file a report. And the report has been served upon me also. Now this matter, my lord, the co-sharer has been.
Sir, are you filing your exception? You're not filing your exception.
No, my lord.
No. This is, but the report is in my favor.
My lord, this is
Very
third time same party repetition against the same parties.
Sorry, sir, I'm not able to understand. What?
This is third time same litigation against the same parties.
Third time litigation.
third time litigation.
Lordship has already raised a maintenance point regarding as the earlier petitioner dismissed particular without restoring the same. This petition has been filed, and the petitioner says that they could place some judgments on the point.
Oh, yes, yes.
But this point was raised
Yes.
at the time when initially the writ petition was moved. My Lord Justice Kochindo did not hear this point and passed in.
I'll come back in 5 minutes. I'll come back in 5. $96A. I'll be back. Okay.
Yes.
No, my lord. These matter relates to an unauthorized construction.
Yes.
Now, when this matter was initially moved on 30th September 2024 before my Lord Justice Kaushik Chondo, this point was raised by my learned friend that the writ petition is not maintainable, keeping in view of the fact on the same issue, the writ petition was filed, that was dismissed for report, and therefore without restoration of the same, now the subsequent writ petition, this is instant was filed.
Yes.
Now my Lord Justice Kaushik Chondo did not ignore this point and passed an order directing the municipality to submit a report. A report was submitted, report was supplied also me, but the report is in my favor. Now, Lord, these allegations regarding the unauthorized construction which was carried on, now kindly see, we raised an objection. I filed a writ petition before my Lord Justice Somapti Chatterjee as the lordship then was, and kindly see the order of my Lord Justice Chatterjee,
The first order is for representation,
representation.
to decide your representation.
Yes.
Para 36,
Representation
page
page
37.
page 34 and order my Lord page 36.
Page 37.
37 relevant.
Yes.
But thereafter, my Lord, by virtue of that order,
Yes.
inspection was done by the municipality.
Yes.
That is my Lord, page
Page
39.
Page 40.
Page 39 and 40, my Lord, municipality issued order stop construction.
Yes.
Now, thereafter, my Lord, again I made a representation before the municipality,
Yes.
page 41. Now,
Yes.
although later, page 49 and kindly see 50, demolition order,
Yes.
page 50. But in spite of that, they did not demolish that, and municipality is not taking any action. Since my Lord, your lordship knows, under section 280, the municipality has got the power to demolish if the my Lord unauthorized enclosure failed to demolish the building. Thereafter, I made another representation.
Yes.
Another representation, and my Lord, this further letter was issued, page 53. Letter was issued, page 53.
Yes.
For stop this construction, can you see? You remove the materials from the public pathway.
Yes.
And next month, page 54.
Yes.
Stop construction. But 3 times letter was issued for stopping of the construction. Demolition order was issued. But in spite of that, he didn't care for that. He has raising this construction, in spite of the stop order, in spite of the demolition order. Now, he is carrying on the construction under the Pradhan Mantri Awas Yojana scheme. I have bought the scheme that is, you can construct up to 300 square feet. Now, he has made this construction 900 square feet. And municipality filed this report, deviating the guideline of the Pradhan Mantri Awas Yojana scheme. He has constructed, thereby passed this order for demolition.
Yes, you appear for the municipality.
No, I'm private restored.
Yes. What is the report? There is unauthorized construction. You have booked the property. Why no action has been taken?
Order has already been passed. After that, they have again tried to construct and stock some material on the pathway. I have again taken the notice, and my lord, there was already a petition order, but we need some time to carry on that.
My lord, the municipality, my lord, first of all, this writ petition is not maintainable because this is the first time, third time litigations. Even the same parties. First, the writ petition was filed in the year 2019, WP number 12693, wherein Honorable Justice Somapti Chatterjee heard in length and directed the municipality to measure the situation, everything to carry on, whether the illegal construction was going on or not.
On the compliance of that report, all the measurement has already been done.
My lord, I have constructed building.
Show that judgment which you were showing last time.
My lord.
Just a minute.
I have constructed according to
You have got the copy?
Yes, I have given this copy. I have given the copy. Yes,
For
my
the
lord.
court. Yes.
Only, I think, my lord, only one judgment is
79 Supreme Court.
No, I have a
Just a minute, wait.
Yes.
Yes.
It's also
কোন জাজমেন্টটা রিলে করছিল রিঙ্কু মন্ডল
no. দিচ্ছি
Paragraph 10, I am reading, my lord. Now, Osnak Singh. Paragraph 10. After 20th line, however, after 20th line, kindly see, however.
citation, please say the
79 bolam to.
citation name ta
Osnak Singh. Has also got it. However, while negativing the contention on the facts of this case, the court reaffirmed that if the petition is dismissed illimini without passing a speaking order, then such a dismissal cannot be treated as creating a bar of res judicata. Similarly, in Tilok Chand, Moti Chand versus H.B. Munshi, a majority of the judges affirmed this ratio of Dairo's case that if a petition under Article 220 is dismissed not on merit, but because an alternative remedy was available to the petitioner, or that the petition was dismissed illimini without a speaking order, such dismissal is not a bar to the subsequent petition under Article 32. It must follow as a necessary corollary that a subsequent petition under Article 226 would not be a bar by the principle of analogous to res judicata, reaffirming the view taken on the point of Dairo's case in P.D. Sharma versus State Bank of India. The preliminary objection about the bar of res judicata was negative. It is therefore incontrovertible that where a petition under Article 26 is dismissed illimini without a speaking order, such a dismissal would not constitute a bar of res judicata to a subsequent petition on the same cause of action. On relying upon this judgment, yes, relying upon this judgment, our High Court has delivered the judgment, division bench.
কপি দিয়েছেন আমাদের রিঙ্কু মন্ডল আচ্ছা আচ্ছা
দিয়েছি মানে হ্যাঁ হাইকোর্ট হাইকোর্টটা
Yes.
Paragraph 25. I mean, I've been reading that while.
Para
25. I'm reading that one. I'll see from para 24. That will be clear. Mr. Koron then cited the judgment passed in this case of Ishwar Dotto versus Land Acquisition Collector and another, reported in 2005-7 SCC 190. In support of his contention that the first retribution having attained finality, the principle of res judicata applied, and that the said principle included the principle of estoppel. We have no hesitation in summarily rejecting the aforesaid contention and holding that the said judgment has no application in the facts of this case because the first retribution was never adjudicated on merits, and therefore the second retribution was certainly maintainable. In this context, we refer to the judgment passed by the Honorable Supreme Court as cited by the Learned Counsel of the appellant, and the past of these judgment are in this case of the judgment has been cited that has been relied upon. Yeah, 1917 Supreme Court, paragraph 10 of this judgment clearly lays down that it is incontrovertible that where the petition of Article 226 is dismissed illegally without there being a speaking order.
My lord, we have counter judgment regarding maintainability point.
yes.
May I refer? My lord, I'm giving you a copy of this judgment.
Another judgment has 85 judgments.
My lord, first of all, the first judgment was decided on merit. That is Justice Honorable Justice Somapi
My lord, dismissal order I have annexed. Last page.
Seen it, sir.
My lord, Somapi Chatterjee, first judgment was delivered on merit. Thereafter, second writ petition was filed, which was dismissed for default, but they have not tried to restore.
Sir, the first judgment which has been decided is only to the extent of deciding the representation. There is no finding. All right. On that basis, an order has been passed, which he wants the implementation of the order. He had filed the writ petition, which was dismissed in limine. All right. That is the status. So don't say the first decision has been decided. And it is barred by res judicata. It is not. Now tell me what is there in this
Let me
petition.
come. Whether I was constructing or legally or illegally, they have raised a contention, and on the basis of the honorable justice, for that no illegal construction should not be carry on. First of all, because I was constructing the building according to plan sanctioned by the municipality. I have a copy of the plan.
All that you have to tell the municipality, not here.
Thereafter, the second writ petition was dismissed for default, and this is a third dismiss, a third writ petition. On this basis, I am relying to this judgment. I have called at paragraph 7, my lord.
Yes.
Paragraph 7. There can be no doubt that the fundamental rights guaranteed to the citizens are significant favor feature of our constitution, and high courts under 226 are bound to protect these fundamental rights. There can also be no doubt that if a case is made out for the exercise of its jurisdiction under Article 226 in support of a citizen of fundamental rights, the High Court will not hesitate to exercise that jurisdiction. But the question as to whether a citizen should be allowed to challenge the validity of the same order by the successive petition under 226 cannot be answered merely in the light of the significance and importance of the citizen's fundamental right. The general principle underlining doctrine of res judicata is ultimately based on the consideration of public policy. One important consideration of public policy is that the decision pronounced by courts of competent jurisdiction should be final unless they are modified or reversed by appellate authorities. And the other principle is that no one should be made to face the same kind of litigation twice over, because such a process would be a contrary to consideration of fair play and justice. As per first direction, there was a measurement was held, everything hearing was held. On that basis, a measurement was held, and a report was given to me, and that report was in Bengali written. If your lordship allow me to submit a affidavit in opposition, I can file in the translator. There is no further on the report. It is stated the petitioner has encroached land more than 550 square foot. Then I have only encroached the entire land is Ejmal land. There is no partition in between the parties. I have encroached only 15. There is no report in the that I have constructed building by violating the municipality plan. I have sanctioned plan, my lord. I have sanctioned plan. Here I can give you. Thereafter,
Sir, all that you have to show at the time of demolition order. You don't show it here. All right.
I have a sanctioned plan, sanctioned the municipality,
good.
competent authority, sanctioned the municipality
Very
plan.
good. Very good.
Thereafter, I have again to construct the second floor. I have applied to the building for plan. I have deposited the money, and they have sanctioned the plan. Now they have come to stop that first floor.
You file your petition. You have a separate right against the demolition order. Have you challenged the demolition order?
My lord, I am poor very person. I have not done anything wrong. I have whatever done according to the sanctioned building plan, my lord. Furthermore,
Just a minute.
my lord, furthermore,
Just a minute.
just
218.3, my lord. He has not challenged the order, my lord. Now he cannot submit.
Yes, yes.
no, my lord, I'm referring to 218.3. The petitioner has not challenged that order of the municipality. Petitioner could prepare again. Petitioner has
All right. You have made your submissions.
no, my lord. Just 1 second. As per direction, the municipality did not stop me construction after that very measurement and allow me to construct the building, and therefore the second time to complete the second floor, first floor, accepted my fees for and submitted my plan and sanctioned the building plan. That which means I have legal right to construct the first floor. And in that time, municipality did not issue me any stop construction order. The earlier stop construction order during pendency of this writ petition. After disposal of writ petition, they measurements taken and there is no encroachment, no violation of the building plan. Thereafter, I apply for construction of first floor, and municipal taken fees and sanctioned building plan. And this petition has come before this court to stop that construction. Against that order, the petitioner has not challenged before the competent civil court regarding under the provision of section 218 subsection 3.
218.3 is the remedy of the private response.
Let him finish.
Yes.
As because municipality has not passed against any order. On the contrary, it has taken fees and sanctioned building plan for the first floor. So why I should go to the civil court?
You're done?
Yes, my lord.
Take your seat. Yes.
I have surveyor in the LRO contact one. After that, this notice has been issued, my lord.
Sir, why we are not here? Why you are not carrying out the order of demolition? How much time?
Order, give some time, I'll carry out the order, my lord.
Carry out the order. Take down. The petitioner has,
Or may I take leave, my lord? May I take leave?
you take leave, then you,
Junior will be here. my lord.
petition can go either way.
Then I have to.
You should be here.
My lord, may I submit the sanction building, copy of the sanction building plan? My lord, may I submit the sanction copy of the
When you are on a sticky wicket, you should stay.
Then I have to stay, yeah.
Your wicket is not that strong. It's a sticky wicket you're on.
The matter will be called up.
All right, go. The petitioner has preferred the present writ petition being aggrieved by the inaction of the on the part of the respondent authority in failing to initiate or take effective and timely steps to halt or demolish an alleged unauthorized construction being undertaken by the private respondent at plot situated in Moza, Jalal Khabar, comma, jail number 310, comma, dag number 301, full stop. Despite repeated complaints and despite repeated complaints, the respondent authorities have not taken any steps to stop the unauthorized construction or to demolish the same. Full stop. The respondent municipality has filed a report pursuant to the direction of this court. The said report has categorically admitted that the private respondent has carried out construction work in violation of the Pradhan Mantri Awas Yojana PMAY bracket mein scheme.
Municipality had not stated that they have sanctioned the plan, they have not.
Sir, please, you have made your argument, I'll record it.
I accepted the report of the.
Sir, I'll record your submissions, please. Full stop. It is further stated that a demolition notice under section 218 of the West Bengal Municipal Act 1993 was issued on 13/7/2021, comma, directing the private respondent to remove the unauthorized construction within 7 days, comma, failing which the municipality would proceed with the demolition at the cost of the violator, full stop. The municipality has also admitted that the private respondent had encroached upon a public pathway by stacking construction materials, comma, for which a separate notice was issued on 9/11/2022, directing removal of the obstruction. Full stop. A work stop notice dated 9/11/2022 was issued 19/11/2022 was issued. However, a bare perusal of the report reveals a grossly negligent and lackadaisical approach adopted by the respondent authorities. Full stop. The report, comma, filed pursuant to the order of the pursuant to the order of the honorable pursuant to the order of this honorable court in WPA number the file pursuant to the honorable court's order dated 30th 9 2024 is based entirely on an inspection carried out in the year 2019, full stop. No fresh inspection has been conducted to assess the current status. Wait, 300 square feet. नहीं 12/7/2019 वो जो है ना 30th 9 नहीं है 12/7/2019 12/7 order dated 12/7/2019 क्या लिखा है no fresh inspection has been carried out full stop. The demolition order was issued far back on 13/7/2021 full stop. It is evident that no steps have been taken to enforce it. The private respondents have continued their unauthorized construction unabated. Full stop. Learned counsel for the private respondent states that the said construction has been carried out in terms of a
Sanction building plan, my lord.
valid sanction building plan.
Sanction building plan, my lord.
Full stop. He further contends that the present petition is barred by res judicata since the petitioner had filed, since this is the third round of litigation. He has drawn the attention of this court to WP 12693 W of 2019, which was disposed of by this court on 12/7/2019, wherein the court had directed the authorities to consider petitioner's representation dated 24th April 2019 within 4 weeks from the date of communication of the order, after giving an opportunity of hearing to the petitioner or his authorized representative and the private respondent and his authorized representative, and thereafter communicate the decision to the parties within 1 week. Full stop. In view of the said order,
My lord, as per sanction plan, I have constructed the ground floor. Thereafter, I applied for first floor.
sir, can you please in where is this practice of interfering when orders are being dictated?
Sorry, my lord, sorry.
क्या लिखा है? In view of the said order, the respondent authority had conducted an inspection on plot 301 Moza Jalal Khanbar, ward number 14, wherein the private respondent had carried out the unauthorized construction. वह जो इंस्पेक्शन का डेट है ना 16/8/2019 डालना ऊपर, ठीक है. After the inspection, a work stop notice was issued to the private respondent. Full stop. A notice of hearing was issued to all the parties on 7/1/2021 in terms of the order passed by this court on 12/7/2019 in WP number 12693 of 2019. Full stop. After that, demolition order was passed by the Board of Administrators on 13/7/2021. Full stop. The said order has not been assailed by the respondent. Says that he has not challenged the said order since respondent is coming from a weaker section of the society and is illiterate. That is your ground of not challenging the demolition order. Since you are coming from the weaker section of the society and illiterate, you can't challenge the order, right?
I think I have no at the time I have no capacity.
That's what I'm saying. Yes. What else?
I told them whenever the petition was filed, they stopped me from the construction. Notice are issued. I stopped the construction. Thereafter, a measurement was held as per that order. That this is a report. Well, my lord,
We are not traveling to that, sir.
No.
All right. Take down.
No, my lord. Just my lord. As per measurement, I have there is no violation of the building plan. Therefore, municipal did not stop construction.
Sir, you challenge that order. This is not your writ petition. The ground of the private respondent, the petitioner, private respondent further states that the petitioner thereafter, since no action was taken by the municipality, the petitioner filed writ petition number WPA 26298 of 2022, which was dismissed in default. Full stop. Counsel for the private respondent states that the present writ petition is barred by res judicata. Full stop. Learned counsel for the respondent municipal authority states that they will, that after due inspection and hearing, the order of the demolition dated 13/7/2021 was passed. Full stop.
Hearing was not given, my lord. On the basis of the report of the BL and LRO, this demolition notice was filed, my lord. Issued.
After the inspection, along with the assistance of the BLR, the inspection along with the assistance of the surveyor of BLRO, the demolition order was passed on 13/7/2021. Learned counsel for the respondent municipality states that the said order has not been implemented due to negligence on the part of the municipal authority. Full stop. The learned counsel, the respondent is not in a position to answer why till date the said demolition order has not been given effect. Full stop. This court has heard the arguments advanced by the counsel for the parties. Full stop. Counsel for the parties and has produced the materials on record. The ground of the issue of maintainability raised by the private respondent is not attracted in the present writ petition, since the first writ petition WP 12693 of 2019 was only, which was disposed of on 12/7/2019, had only given the liberty, had only given the direction to the respondent authority to decide petitioner's representation, and no rights were created by that order. No decision, no concrete decision was taken by that order in terms of the allegation of unauthorized construction. Full stop. The second petition filed by the petitioner was dismissed in limine and was not adjudicated, and the petitioner has relied upon a order of this court in FMA number 2408 of 2004, which supports the contention that if a petition has been dismissed in limine, the ground of res judicata or a bar under 226 cannot be imposed for filing fresh petition. Full stop. The इसका para quote करो. Which paragraph is the relevant para?
In our High Court judgment.
In to support the said contention, the petitioner has relied on paragraph 25. Full stop.
Judgment में होता है.
In view of the said submissions, this court is of the view that the present writ petition is squarely covered by the dicta of the above mentioned judgment, and even in the present case, the writ petition was dismissed in limine, and that possibly cannot be a bar to a subsequent writ petition. Full stop. This court directs the respondent municipality to carry out the said demolition order within a period of how much time?
4 months.
Why 4 months? You have taken 6 years. You want 4 months? 21 orders, sir. We are sitting in 25. Within a period of 4 weeks.
8 weeks, my lord.
How much?
It needs some time. Police help required.
How much time?
8 weeks.
8
weeks.
8 weeks.
2 months.
Within a period of 8 weeks. Needless to state, the PS, the inspector in charge, Contai Police Station, shall render all assistance to the respondent municipality for carrying out the said demolition action at the cost of the petitioner. With the above direction, the present writ petition is disposed of. ये देखिए
May I please your lordship, my lord? I beg to appear for the petitioner, my lord. On last occasion, there was a direction upon the municipal authority to file a report. Now they have served a copy upon me. I was just seeking, my lord, if I can take out an exception to their report.
Who's appearing? You're
Lord,
appearing?
I appear, my lord, on behalf of the town vending committee of the corporation.
They have filed a report, my lord. They have served it upon me. I would like to take an exception, my lord. I'm praying for that before your lordship.
Mr. Chaturvedi,
My lord.
you know, since you are appearing in this matter,
My lord.
have you carried out the surveys in terms of the surveys required here also?
It is required as per my instruction, my lord. The survey has not been carried out. Although in their report, they are saying that they have carried out a survey in 2024, my lord.
May I? My lord, we have stated on affidavit that there have been two surveys, one in 2015 and the second one has been done in 2024. Lord, kindly takes up my report, Lord, on record.
Exception.
Lord, we should kindly allow us to take an
I
exception.
will. I'm just trying to.
Madam,
Mr. Chaturvedi is here.
Kindly,
Let us use his good office to sort
My
out
lord,
the
my lord.
issues. You know, this is always a problem. Yes.
My lord, in paragraph 6,
Records are there.
Yes.
Lord, I have said that the recent survey conducted by the town vending committee in the year 2024 is being considered by a 5-man committee on the hawkers issue and certificate of vending. This will certificate of vending in terms of section 4 of the statute
Yes.
will be issued to eligible persons in the list provided they carry on their livelihood on the street without violation of the Street Vendors so and so Act 2014 and my lord, the West Bengal Urban Street Vendors so and so Rules 2018. I further say it has been decided by the town vending committee that a total 54,178 number of street vendors whose details have been collected during survey along with their locations and photographs of the vendors have been collected from the electronic mode also, and the town vending committee is working on it to facilitate the street hawkers in terms of the street hawkers so and so. And then Lord, the previous
Lord,
paragraph.
pleading without evidence.
Yes, yes. I'm not passing any order, Mr. Bhattacharya. I'm just reading that what have they stated.
Ma'am.
I'll give you time to file your
Ma'am.
exception.
We shall file it.
Lord, kindly comes to the previous paragraph, paragraph 5. I said that the names of the petitioners are not there in the surveys conducted by the town vending committee in the year 2015 and in the year 2024, and such status of the petitioners is indicative of their being unauthorized vendors, and as such the question of cancelling or suspending the license cannot and does not arise. So Lord, two things. Lord, one, that they were never licensed vendors. There was no certificate of license granted to them. Their case in the writ petition is that 26 of them have clubbed together to espouse a common cause, although the injury is individual in nature. And to that effect, I shall rely on a judgment of our court that if there is no jural relationship, they cannot join together. That issue was taken up by me on the first day. Justice Chando said it was at the brink of the vacations in October. And the question was that of giving some relief to the vendors if possible.
But they're not an association.
They're not an association.
Then how have they filed it?
That is, hence, my lord would decide that issue, only on the last occasion, I was, asked to, since a point was taken that in the survey, our name was there. I could not readily answer that query because 58,000 odd names will not have to be screened. So I said that very well, to the limited extent, I, would file a report. His lordship, gave me, such liberty. I am filing, my report. The relevant question, I placed before my lord.
They can't maintain this writ petition like this. Will not kindly will not seize this decision of our court.
বুঝলো, এখন তো আর্গুমেন্ট চালু করে দিল।
So this is the year 2011 Calcutta, page 1.
Single judge.
Yes,
It was not challenged.
not challenged, Will not.
Yes.
To my knowledge, not challenged. Will not kindly seize the first paragraph, starting with the words 310 individuals claiming to be unemployed youths have registered the name in the concerned employment exchange, have joined together to file the instant writ petition, praying inter alia for the following reliefs. And then will not kindly permit me only to read will not the nature of relief. A writ of in the nature of mandamus do issue commanding the respondents, the agent servants, particularly the district primary school council, being respondent number 4 and 5, to rescind, cancel, and withdraw the entire selection process of the primary school teachers under the jurisdiction of Malda District Primary School Council. So they were individually affected by it, but they clubbed together, not under the aegis of an association, registered association, but individually. And then kindly seize paragraph 2. A preliminary point has been taken by the learned advocate representing the respondents number so and so, who submit that each writ petition has its own independent cause of action, yet they have joined together to file the instant writ petition without even paying the necessary court fee. And on this ground alone, the instant writ petition is liable to be dismissed. In this regard, he relies on the judgment of the Supreme Court in Mota Singh. Then, my lord, 80 Supreme Court, my lord, was relied. Then, after considering paragraph 4, after considering the submissions made by the learned advocates for the parties and upon perusing the instant writ petition, it appears that the writ petitioner has submitted their documents and testimonies along with the biodata forms before the concerned so and so. There exists no jural relationship inter se the writ petitioners. The only common thread of joining as co-petitioners appears to be their status of being unemployed youths whose name were sponsored by the concerned employment exchange for the recruitment of the post of assistant teachers under the DPSC Malda. In my opinion, having regard to the facts and circumstances above, this is not enough for the writ petitioners to join as co-petitioners and instituting the writ proceeding in the absence of a jural relationship between them. In case of Mota Singh, then Lord Mota Singh Lord has been Lord relied upon, and then Lord the sub paragraph after the portion in court is in the backdrop of the above made by the Supreme Court. The view of this court as enumerated stands fortified. Lord, kindly seize, Lord, what have they prayed in this writ petition? Lord, kindly comes to Lord, page 17. Lord, C, to issue a writ of mandamus or any other appropriate writ or order or orders, thereby direction, thereby immediately reinstating the petitioners in their hawking stands. Then a writ of mandamus, any other appropriate order, direction, thereby setting aside and quash any decision or survey report as being illegal and made in absolute violation. Then prohibition restraining the respondent authority from evicting the petitioners. Now, if any of them is evicted, I take such proposition first, then each one suffers an individual injury. If each one says that he has to be reinstated, then each case will have an individual merit to be considered. An individual right has to be asserted. It has to be determined.
Mr. Bhattacharya, everybody would have got if at all, a license on different dates.
But I will place this. This has been followed in 2017 by Justice Banerjee. little contrary view has been taken.
Why have you filed?
Lord,
you could have filed
the
separately.
the street vendors, 26 street vendors have come.
Either you make association of street vendors.
Lord, they can pay the court fees for 26 court fees. In one writ petition, it could be decided. Lord, I'll satisfy your lordship. Lord, there is no problem. Kindly allow me to come back with an exception to this report. Firstly, they have only pleaded, and pleading without evidence, my lord knows Bharat Singh, my lord, 84 Supreme Court, the pleading without evidence in a writ proceeding, Lord, cannot be taken into consideration. They are talking about surveys. The corporation is hiding that document.
File an affidavit
Yes.
in opposition, taking all
Yes.
Kindly sees, my lord, the last order, my lord, the direction upon me.
The direction was that report in the form of an affidavit. Yeah, I'm telling that only, sir.
Yes.
Thank you.
4th October.
The court allows the corporation to file a report in the form of an affidavit to deal with the allegations made in the writ petition. So that means you have to deal with the allegations in the form of a report in the form of an affidavit. So if you are dealing with the allegations relying on a document, it's your duty to annex. That's Bharat Singh, 84 Supreme Court.
Very well.
But I'll file an exception, my lord, or a reply to this and come back.
Kindly sees, my lord.
Mr. Chaturvedi, you
I can come if my lord directs, my lord, an affidavit. I have, my lord, filed, my lord, this report in the form of affidavit in terms of, my lord, kindly sees the last
Lord,
paragraph.
my lord has been to this
May I
area.
read the sentence?
My lord has been to this area, this esplanade area, this area. My lord, it's one of the in our younger days. There are no malls, not of these malls, my lord.
I know
Hog
about the
market,
area.
Hog market, New Market.
I've not
You
been
lords
there.
will find hundreds, thousands of vendors.
That's right.
Now, if you are aligned to a particular political party who are at the helm of affairs, all laws will be in your favor. If you are aligned to a different view, then this sort of opposition will come, surveys will not be given, certificates are there, surveys are not produced before the court. What prompted the corporation not to produce the records? After 4 months, you are filing it. You are way up beyond time. What Mr. Chaturvedi was doing, when was it directed to be filed? The time has elapsed long back. Today he is handing over. When was it affirmed? Sir, this was affirmed in February. May I ask him, what was he doing for the last 3 months? See, this was affirmed in February, my lord. I could have dealt with this. Now, today I am being surprised with the submissions and all that. I'll deal with this. From February, they are waiting with the affirmed copy. They could have served me a copy.
In my court, only I raise my voice.
Of course, my lord. Of course.
My lord,
I'm sorry.
only one thing, my lord, possibly Mr. Chakraborty is not properly, my lord, instruct access.
Sorry.
When I'm talking to the court, I'm talking to the court. I'm not listening to anyone else.
Thank you.
Lord, I served it on 18th February. Lord, kindly, my lord, trust me for my words, or else, my lord, the signature
No,
endorsement is
absolutely.
here.
Such a no question of not trusting you for your words.
My lord. Now, my lord, I was, my lord, inviting my lord's kind attention, my lord, to the order passed on the 4th of October. My lord, kindly sees the last 3 lines of the second paragraph. The report of the corporation shall indicate the status of the survey conducted for issuance of street vending certificate. And it is, my lord, the direction was only to file a report in the form of affidavit indicating this. If my lord, my lord directs me, I'll certainly, my lord, avail of the liberty, my lord, which my lord grants me. I shall file a comprehensive affidavit in opposition.
Because
But today, my learned friend is to take a call as to whether he runs the risk and presses for this writ petition being taken up, notwithstanding the objection taken by me.
that Mr. Bhattacharya has to.
Lord, I will file a rejoinder to this, my lord, affidavit or reply, and then you also will decide the matter.
So he presses for the writ petition to be heard on merits. Kindly records, my lord, that I have raised an issue of maintainability.
Lord, the maintainability, as far as my lord, the law that I have learned from your lordship, my lord, all the maintainability, if it goes to the jurisdiction, my lord, you also will decide. But this point was not taken perhaps on the first day when the matter was moved. And my lord, today it is being taken. Lord, I'll deal with that in my reply. My lord, here's the matter. Whatever is the outcome.
Well, my only question is that with this report,
Yes, that's the point.
there's nothing in the report.
Yes.
But the report, yes, kindly sees, I have indicated 2 things. The court's query was whether there is a survey and what is the status of survey. Only, my lord, to ascertain as to whether the names of the petitioners are at all in the survey list.
Which
If-
is where you are saying they are not there in the survey.
And
the petitioners have said that they are licensed vendors. In support of this, what they have, my lord, annexed, my lord would kindly see, are only applications which they make for grant of license. Kindly comes to page 21 of the writ petition.
Yes.
Lord, kindly sees, Lord, the third line on the top head, hawker registration application. They construe this application to be their license. This was indicated to the court on the first day, and the court, my lord, consciously recorded that there is nothing on record to indicate that the petitioners have a license. But then a submission was made that there is no survey in terms of the statute. Let the court even directed me only, my lord, to, my lord, see whether, my lord, these poor people can be rendered, my lord, any relief. The court said, you file a report in the form of affidavit only to indicate whether there has been a survey, and if yes, whether the names of the petitioners are there. My lord, I put a question to myself, why such a direction was passed? Such a direction was passed only, my lord, to see whether any relief can at all be granted. If their name is not in the survey, then possibly they have a new cause of action that I have made an application. I was there. These are the documents in support of my existence, yet my name does not appear in the survey. That is another cause of action. Here what they say is that we are being evicted without due process of law. We are licensed vendors. Now, licensed vendors means in terms of section 4 of the statute, my lord would see that there has to be a, I'm sorry.
Yes.
That
I've
there
seen
has to be, my lord, a license in terms of section 4, my lord, to be issued. This is a certificate
But
of
that is subsequently. You know, this license would come into play only after the survey has been completed. Then you will issue a license to them. This is not, see, their contention is different. What their contention is, you are right to one extent, is that yes, there's only registration. There's no license.
No, there is, even
The applications which are there on record, which you are showing to this court,
that they have made an application.
they have only made an application,
Right.
but there is no decision which has been taken as far as the application is concerned. So they don't have any license.
They don't have any right, and the applications, my lord, they are considered in the survey along with, my lord, the survey report to see whether the application has been made by an existing person who is there and who is not vending unlawfully on the blacktop. My lord knows, my lord, the blacktop of the street.
Yes.
The blacktop of the street.
Come on. Yes. Few matters have been here with.
I'm grateful. Yes. So, but that is, my lord, the case made out. That is the case made out that I am licensed vendor and I am being evicted without due process of law. And in support of that, they show page 21.
Mr. Chaturvedi, I want to understand one thing for my own knowledge. Like in Delhi, when we are vending, so there is a receipt which is given to all the vendors. No. Do you have any receipt or anything of that sort? Because you have not annexed anything.
As per our instructions, what we receive from the petitioners, that with this application, when it is made, they are not for long time, 10, 20 years.
Whatever it is, some sort of.
In 2015, page 21, in 2015, these applications were made. From whom the applications are taken? The persons who are regularly doing business there. Now, on the applications, there was a survey made. I'll place the act also, since Mr. Chaturvedi is saying. And survey is made. Then they found out. Then they grant license. With this, we have been continuing since 2015.
This is subsequent, Mr. What is your ground?
Yes,
Your
ma'am.
case would be that I have been carrying out vending activity from this zone for 100 years. Literally, this is what every vendor says.
Yes.
You know, I've been sitting there for, you know, my father was there, my grandfather was there, everybody was there. What document do you have to establish that you were vending from that particular site?
Page.
That is the document which you need to give at the time when the survey is being conducted in terms of section 3.
Let the report comes. I have instructions that our names are there in the survey. They are from that area.
They have filed a report.
They have not annexed their survey. It's only a document without any evidence.
Mr.
That's a pleading without any evidence.
What document have you filed on record?
Lord, I have filed this application. Something has been done on this application. Rejected, allowed, something has been done. Kindly come to page 21 once.
Yes.
Kindly see.
Yes.
Kindly see. It is on the Kolkata Municipal Corporation's
They have
case.
not, suppose they have not taken any action on this application, then
Lord, there could be two things. Three. One is allowed, one is rejected, one is kept pending.
yes.
Nothing else than could have been done. Now their affidavit, I am yet to go through. Lord, that's why I prayed for some time to
I'm
come
giving
back.
you time, Mr. Chair. I'm
Yes.
deciding.
Now, today, before Justice Chando, what they
I'm
said,
just of the view that do we need to get a better affidavit in terms
yes,
of
let
affidavit
them
in
come back, let
opposition?
them annex the survey.
I can file an affidavit in opposition, my lord, if my lord directs, my lord, I shall
Let
surely.
him file.
Mr. Chaturvedi, you tell me what would be better to adjudicate this matter?
Yes.
Will this
I'll
report
file a
help
composite
for
report.
the final adjudication?
My lord, a comprehensive report, my lord,
Yes.
no doubt, my lord, would assist my lord, my lord,
Affidavit.
in adjudicating the writ petition more comprehensively. But my lord,
Comprehend-
kindly,
Comprehensive affidavit, my lord, with documents supporting the allegations. Let them file, my lord. I'll deal with that. My lord decides them.
I'm sorry to say, my lord, I'm a little too frequently being interrupted. I did not expect this from Mr. Bhatt.
Lord, I don't
Mr.
interrupt. Lord,
Mr.
I'm just,
Bhattacharya, you
I'm
don't do
just,
this, and that too a senior.
but I'm just
advocate.
answering your lordship's query, my
I
lord,
don't know
not
what-
interrupting. He was arguing, Lord, I did not interrupt him.
You'll get your chance.
My lord, let him say.
This court is not in a hurry.
Let him. No, I'm not.
I'll
I'm
hear
not
you,
at all.
I'll hear
I'm
you,
not
both
at all.
of you.
I'm sorry if he's felt that I'm interrupting. Kindly carry on. Kindly.
Yes.
My lord, kindly see, my lord, paragraph 3 of his writ petition. This is a sum and substance. If he, my lord, if he qualifies whatever he says in paragraph 3, Lord, I bow down to your lordship's, Lord, a comprehensive affidavit would be required. Lord, kindly sees the third line starting with the words, all of your petitioners have license and registration issued by Kolkata Municipal Corporation. This is, my lord, the foundation of his case.
All right. You file your exception.
I shall file.
Let them file their exception.
Exception.
Exception. What do you? I think that'll be better. Let them file their exception. In the exception, they will file.
If required, my lord would direct me to
No, my lord, then
file an
with
affidavit.
greatest of respect, my lord, after I file my exception, subsequent opportunities, my lord, I will then, my lord,
That will
kindly
waste
allow me
time
to
on the
raise that.
court, that will
Yes.
waste time.
Yes,
This
kindly
will
allow me
go
to raise
on
that
for-
objection, my lord.
This will go on for a long
Yes.
time, Mr. Chaturvedi.
Yes.
So let us put an end to this.
Yes, yes.
If you want to file an affidavit in opposition, bring
I
it.
shall.
Then I'll give a direction.
But not only one humble prayer before your lordship, my lord. A little shorter time, my lord,
Yes,
maybe.
we'll try to do.
My lord.
We'll try to. Learned Counsel, the respondent has filed a report in the form of an affidavit. Full stop. This court feels that the same is not
দুজনেই ভট্টাচার্য।
adequate to decide the present writ petition, wherein various grounds have been taken by the petitioner to substantiate his claim of vending. Full stop. Learned counsel for the senior counsel for the respondent, Mr. Chaturvedi, also raises the plea of maintainability of the present writ petition, since
এই জাজমেন্টটা লিখে নাও।
he states that raises the ground of maintainability of the present writ petition, since the petitioners in the present writ petition are not registered hawker association or any other association, but are individuals whose rights are affected in one way or the other by the action of the respondent corporation. Full stop. He further states that the petitioners cannot combine the relief which is sought by them in one single writ petition, since each individual petitioner has different sets of facts and relief to be sought from the corporation. This is, Mr. Chaturvedi,
Yes,
this is your submission?
my lord. My lord.
I hope you are paying attention.
Yes, I was, my lord.
All right.
And I relied upon the decision which my lord would, of course, refer in my lord's order.
Mr. Chaturvedi, to buttress his argument, has
But Mr. Chakraborty.
Mr.
Chaturvedi. Sorry.
Mr. Chaturvedi, to buttress his argument, has also relied upon the decision of this court in what is
2011,
AIR 2011,
Calcutta 1.
Calcutta 1.
11,
Full stop.
10, 11 কিছু একটা আছে। 13 দেখি।
In view of such submissions, this court directs the respondent seeks and is granted
ঠিক আছে?
time to file affidavit in opposition, 4 weeks time to file affidavit, 3 weeks?
4 weeks.
4 weeks. 4 weeks time to file affidavit in opposition. Reply to the same, if any, within
3 weeks, 1 week may it be like that. I cannot bargain, but we are suffering.
operation. Let it be 4 weeks. We'll finish it off.
Within 4 weeks, I shall.
As well as please.
How much time?
1 week maybe.
1 week. Reply, if any, within 1 week thereafter. List after 5 weeks.
My lord has a CPC
6
here.
weeks. 6 weeks.
My lord has a CPC here. CPC.
Unfortunately, our High Court doesn't provide too many books.
Just have a look at this, my lord.
I don't have. Don't have.
Kindly have a look at this, my lord. একবার জজ সাহেবকে দেবে?
You know, in Delhi High Court, every judge has a library in their own court. And we have all bare acts, all acts, everything there. And a restorer is there to assist us with the books.
Delhi
I
High Court.
understand that it possibly requires only a requisition by my lord's officer, and in no time it will be there on my lord's table. Only a requisition.
But I've given you also the book. Just check Order 1 Rule 13 once. Order 1 Rule 13. Just read Order 1 Rule 13 once.
Yes, you can argue it.
So I don't need a judgment to, my lord, counter him. That's the law. He has not taken that objection on the first available opportunity. He cannot take that now. I don't need to show a judgment on this. This, my lord, statute says that he has to take it at the first day, not now. So whatever is the judgment, in Minal Das, the objection was taken on day 1 before Justice Somadar.
He was not there first day.
But the judgment says, but I have read it 2011, that was followed by Justice Arijit Banerjee in 2017. Similar point to objection was taken. Justice Banerjee said, you did not take it on day 1.
But to my understanding, ground of maintainability can be taken later also.
This point of non-jointer, misjointer, maintainability going to the jurisdiction of the court, root of the matter is different thing. Non-jointer, misjointer are the first available opportunity. Like Section 8 of the Arbitration Act, before filing a first defense. So today he cannot take that point.
But he's not taking the
Minal Das,
non-jointer, misjointer. He's
that's
taking
the point.
of maintainability.
But he is saying 20 petitioners, misjointer of petitioners. That is the issue, non-jointer, misjointer. On the day 1, that is Minal Das, it was taken on day 1 before Justice Somadar. Day 1, first day. Today he cannot take that.
That
But I'm
Mr.
get-
Chakraborty's submission, it suffers from
That's the
misconception.
statute.
Misconception.
I also feel that way. I'm not.
I would
will
not open.
place that.
I would not open my cards today.
Very well.
I preserve my energy for the next day.
My lord, we'll come back with that.
All right. The rest of the matters, we can have it tomorrow. Mr. Ganguly, why are you sitting here?
Lord, item 21, I would prefer 2 weeks adjournment. I am for the petitioner. The next matter. The next matter, my lord, kindly adjourn it for
I
2
do not
weeks.
stand on the way. I am appealing for the municipality. Lord, on the last occasion also on Mr. Chakraborty's ground, I did not.
I could not
Anyway, Lord,
contact
I
the
do not
client,
stand
Lord.
on the way.
Only just adjourn it for 2 weeks. I'll contact the client. and come back. Otherwise, it will become futile on my part to appear at 4:30, Lord. There's no instruction as of now. Just adjourn it.
Current counsel for the petitioner, Mr. Chakravarti, seeks
Kindly fix tomorrow.
Sorry?
আমি কথা বলতে আমি petitioner তো আপনার কি আমি টাইম চাইছি 2 weeks at
I am suffering, my lord.
how is he suffering
Because my wife died
how
due to the accident.
how
What is yes?
I tell you also what happened no I tell you also what happened there are two
And-
matters
And kindly
took-
see,
All right, sir, we will have it next week.
Lord, he took out
Kindly fix
My
it
lord.
on next.
he took out one writ petition that got dismissed by Justice Chondo. This is the writ petition. I challenge the matter.
We'll have it next week.
Next week.
Yes. I'm
Wednesday?
next week মানে কবে?
Request for a short adjournment. Let this matter be listed on Wednesday.
No, Tuesday, my lord.
Tuesday.
Tuesday.
Tuesday, my lord, I'm sorry.
Tuesday.
My lord, I will not be here.
Lord,
Tuesday
the
evening,
week
I'll be back.
starting-
My lord, kindly take it Wednesday.
may it be on the 22nd July. 22nd July.
Then my
Next week I have
then
some
my
difficulties, Lord. 22nd July.
No, 20.
Next
Thursday,
Wait.
next week I have some difficulties, Lord.
Thursday, if your lordship so.
Wednesday,
Friday. Let's have it Friday, Mr.
Friday.
18th.
Friday is 18th.
18th.
No, no.
Yes, Friday is 18th.
Yes, 18th. We'll have it on 18th.
18th.
Mr. Ganguly, 18th.
My lord, kindly.
Friday.
Mr. Ganguly has in different matters, Lord.
My lord, kindly 2 p.m.
Sir, next matter.
My lord, kindly 2 p.m. Kindly accommodate me.
No timing by
That
this.
will be called on. Why?
No timing fixed by this.
Yes.
This I will not do. This practice doesn't work here.
Ah.
But I am sir.
No 2 p.m., no 11
But
p.m.
My lord was saying about Delhi High Court. I have seen that the books are kept in the beside in the almirah. It's always available in the room only.
Initially that. Initially,
Kindly
our
say,
High
my lord,
Court,
this
there
is
are
only your lordship
those,
requires your lordship.
lot of books, all are barracks.
Now you all are so educated, you don't need books.
I
No,
am saying since 1980.
we are always learning from my lord.
We have to learn from each other.
That's the. And now this is very effective. This is
Very effective. Very effective. I will also start keeping mine.
extremely grateful to my lord.
I am grateful, my lord.
Excuse me.
Second, no? July, no? We'll have it, nothing. Rest of the matters tomorrow.
Next matter, man, 23.
Tomorrow, sir.
Tomorrow. Grateful.